All rise.
The Kosovo Specialist Chambers is now in session.
Be seated. Good morning and welcome, everyone. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSE BC 2020-07, the Specialist Prosecutor versus Gucati and Haradinaj.
Any change in the composition of the panel for the prosecution?
The only difference is that the legal intern, Nolly Norberg, who was present yesterday, is not present today.
All right, thank you. Mr. Reese, any additions?
No change, Your Honor.
Mr. Cadman?
No change, Your Honor.
Thank you. I note that Mr. Gucati and Mr. Haradinaj are present in the courtroom. As promised yesterday, we will rule today on the joint defense request under Rule 1023 in anticipation of the testimony of witness 4842. The panel recalls first that yesterday it rejected the application of the Gucati defense in relation to new information provided by witness 4842 and found that the additional information was limited in scope and nature and that the information fell within the scope of the witness's anticipated testimony and did not go beyond what the defense had notice of. The panel is now seized of a new request by the Gucati defense and joined by the Haradinaj defense. We will call this defense disclosure request. In this request, the defense seeks disclosure under Rule 1023 of material and information it maintains as material to its preparation for the cross-examination of witness 4842. The defense maintains that this disclosure is necessary as a result of the new information provided by the witness. The SPO maintains that the defense disclosure request is untimely and overly broad. It submits that such 11th hour motions make the witness preparation procedure adopted by the panel unworkable. The SPO also states that witness 4842 is the best source on the matters that the defense seeks to address and that he can be cross-examined when he appears. Before ruling on the matter, the panel recalls that the pretrial judge has held that the defense may request the disclosure or inspection of material not included in a Rule 1023 notice. In such a case, the defense must provide, Roman numeral 1, provide suitable parameters for the specification of any requested items so as to enable the SPO to identify the item sought, and 2, indicate the materiality of the requested items for defense preparation. As regards the parameters of specification, the pretrial judge held that these may include a specific event or group of witnesses, a time period and or geographic location to which the material refers, a category of documents defined by criteria which apply to a distinct group of individuals, or any other features defining the requested items with sufficient precision. The pretrial judge also held that the defense may not rely on mere general descriptions of or conclusory allegations on the requested information and should avoid making requests in the form of catch-all phrases. For the record, that is F-172, paragraph 26. This decision was not appealed by either party, and the panel has no reason to revisit it in the present context. The panel notes that the defense disclosure request encompasses virtually any record the SPO has ever made regarding witness protection referrals, including field measures. It also covers any record the SPO made regarding checks of names against the distributed material. It also encompasses internal meeting records on witness contacts and related managerial decisions since October 2020. The panel understands the defense tried to provide suitable parameters of specification, but the scope of its request goes well beyond the anticipated testimony of 4842. While the disclosure system must provide an effective way for the defense to obtain relevant information, it is not to be used as a fishing expedition. The panel is further not satisfied that the defense made a showing of materiality in relation to this disclosure insofar as it pertains to the proposed evidence of witness W04842. That being said, if during the direct examination the witness is asked to testify to matters that go beyond the scope of his statement and the 14 October notice, and these matters fall under the scope of the defense disclosure request, the defense may make a new request of disclosure under Rule 1023 regarding that specific material or information. The defense should indicate at that time the materiality of that information for the preparation of its cross-examination of witness 4842. Moreover, during cross-examination, the defense is free to elicit information from witness 4842 on specific matters pertaining to the defense disclosure request, provided that they can demonstrate relevance to their case and the line of questioning is otherwise permissible. The panel therefore rejects the defense disclosure request with the caveat just mentioned. This concludes the oral order on the defense Rule 1023. I'm not finished yet, Mr. Reese. Preliminary matters regarding authors of notes. The panel takes this opportunity to note that the SPO exhibit list for witness 4842 contains several official notes not authored by the witness. The SPO is not barred from eliciting information contained in a note prepared by a third party if the witness is capable of testifying to its content, nor is the showing of such notes prohibited if again the witness is able to add to what is stated in the note or to corroborate some or all of its content. However, as previously held, to the extent that these notes fall under Rule 153 or 154 of the rules, they are not admissible through this witness. Where the SBO intends to rely upon a note not prepared by witness 4842, it should ensure that the basis of his knowledge of a fact or circumstance stated in one of those notes is clearly outlined. Now, Mr. Reese.
In our inter-parties correspondence, which raised the disclosure request under Rule 1023, we did, of course, point out that there'd been no updated Rule 1023 notice that deals with the material in the possession of the Specialist Prosecutor that falls within the scope of the 3 paragraphs alleged to be new information in the email correspondence of the 14th of October. It is, of course, not new information, and indeed the prosecution, in their response to our filing F00349, had at that stage suggested that 04842 was in a position to testify on the institutional tasks carried out by the witness security team and provide examples of measures undertaken by the SPO to address concerns raised by witnesses in relation to their safety and well-being.
Mr. Reese,
and in our reply...
Excuse me, Mr. Reese. What's the purpose of this statement? Are you asking for a reconsideration or something?
We still submit that the SPO are required to provide an updated Rule 1023 notice.
Unfortunately, we have ruled on that, and that's what we're going to proceed under.
Well, Your Honour, I understand Your Honour's clear ruling in relation to requests for disclosure under Rule 1023, but of course Rule 1023 has, as we know, 3 stages. The first stage of which is the provision of a relevant notice setting out all relevant material in the possession of the Specialist Prosecutor. The request for disclosure is only stage 3 of Rule 1023.
Thank you. Mr. Potch.
Thank you, Your Honour. Just briefly, the reasons to reject this repeated requests are the same, Your Honor mentioned in your decision, the overly broad nature of the request would also apply to any listing requirements. Thank you, Your Honor.
We will proceed. So the panel will now hear submissions on the admissibility of the exhibits tendered but deferred during the testimony of Ms. Plumper. As said yesterday, the parties should present their arguments on both admissibility and proposed classification of these exhibits. Everyone is also reminded to present their arguments in a manner that does not defeat the confidential classification of the tendered exhibits and which avoids repetition of submissions already made. The SPO and each defense counsel will be allotted 15 minutes to make submissions on all categories. The prosecutor is also reminded to read out concise summary of Ms. Plumper's declarations. The time spent reading these summaries will not be counted for the 15 minutes allocated to the prosecution. The panel will issue a written decision on admissibility and classification after hearing all arguments of both parties. We will begin with the prosecutor. Madam Prosecutor, the floor is yours.
Thank you, Your Honor. I will proceed according to the categories and list of items that have been notified by the trial panel to both parties. And we start with the declarations of W04841. The SPO reiterates its request for admission of P86 MFI, P87 MFI, P88 MFI, P89 MFI, P90 MFI, and P91 MFI under Rule 154. The request for admission extends to the respective Albanian translations of this declaration, which have not been given an MFI number yet. A decision on the admission of these items has been deferred. The requirements of Rule 154 have been met at the outset of this witness testimony. The witness confirmed that she authored this declaration, was present in court and available for cross-examination and questioning by the panel, and confirmed that the declaration reflects what she would say if examined on the specific points. All of the objections raised by the defense in relation to these items address the weight to be attributed in the defense view to the evidence provided by this witness, which is a matter for the trial panel to ultimately assess, and do not impact in any way on the admissibility of this witness evidence, whether provided through oral testimony or pursuant to Rule 154. The classification of each of these declarations is submitted is confidential, as these declarations contain specific references to the contents of confidential materials disclosed without authorization by the accused. The SPO is available to submit a public redacted version of the English version of each declaration, and will be ready to do so within 10 days from the trial panel decision on the admission of these items. And in order to ensure an efficient use of translation resources, the SPO seeks to provide the Albanian redacted version of admitted items once the redaction on the English version have been approved by the trial panel. I will read the summary of the declarations at the end of these submissions. I will move to P0098 MFI, which is an official note authored by W04841 with attached correspondence. This has been already tendered by the SPO in the course of W04841 testimony. W04841 has confirmed the authenticity of the official note and the correspondence attached to this official note. The authenticity of this correspondence has further been confirmed through the testimony of W04866 yesterday and the day before, and I noted that part of this material has been admitted as P000981. The entirety of this correspondence is relevant and probative, as it documents the resonance of the events occurred at the KLA War Veteran Association on the 7th of September 2020 within the Kosovo press. In the SPO submission, the classification of P0098 MFI should be maintained confidential as it contains references to the identity of third parties and could therefore impact on the right to privacy. Proposed redactions for the English public redacted version have already been submitted by the SPO with the filing KSC BC 2020-07 F00324 Annex 1 of 24th of September 2021. I will move now to category 2, which include excerpts of batch 1. These are the items P93 MFI, P94 MFI, P95 MFI, P96 MFI, and P97 MFI. All the disclosed pages of batch 1 have been authenticated by W04841 in the course of her testimony and identified as parts of the documents that have been seized at the KLA War Veterans Association on the 8th of September 2020. Both their relevance and probative value appear evident as they are excerpts of the confidential materials that has been disclosed by the accused on the 7th of September 2020 as charged in the indictment. As previously submitted and mindful of the trial panel guidance in the decision F00350, paragraph 18, the SPO submits that the classification of these materials should remain confidential, as the present proceedings should not become an avenue for publication of information contained in the batches which had not been placed in the public domain before the events relevant to the charges in the indictment. I'll move to category 3, starting with item P99 MFI. And I note in relation to this item that W04841 has authenticated this document as part of the SPO official records, while W04866, in the course of his testimony in the last 2 days, has spoken to the truth of the events documented in the official note and has been cross-examined by the defense, among other subjects, on these events in particular. The document is relevant as it corroborates W04866 testimony on the delivery of batch 4 to the SPO and is probative of the events documented therein. The proposed classification is confidential as the document contains names of SPO staff members. Proposed redactions for the English public redacted version have already been submitted by the SPO with the filing F00324 Annex 1 of the 24th of September 2021. Depending on the trial panel's decision on the request to add W04876 to the SPO witness list, a lesser redacted version of this official note will be provided. Moving to item P101 MFI and P102 MFI, which I will address jointly. I note that P00102 is relevant for the reasons addressed by W04841 in her declaration P89 MFI. This is correspondence received by the SPO, including pictures of pages of batch 1 and batch 4 received by the SPO from a media outlet. And as such, the document corroborates the dissemination of the confidential information disclosed by the accused on the 7th September within the press. P00101 is an SPO official note speaking to the origin of such correspondence and therefore confirming its authenticity. The authenticity of both P00101 and P00102 has been further addressed by W04841 in the course of her testimony. The SPO submission is that these items should remain confidential as they contain references to the identity of third parties and could therefore impact on the right to privacy, as well as the identity of SPO staff member. A public redacted version has already been submitted by the SPO with the filing F00324. Moving to category 4, which includes batch 2, that is item P104MFI. I note that all disclosed pages of batch 2 have been authenticated by W04841 as the documents that have been seized from the KLA War Veteran Association on the 17th of September 2020. They are directly relevant to the events alleged in the indictment as they constitute evidence of the materials that have been found in the accused's possession following the press conference of the 16th of September 2020. Besides 6 pages which have been redacted as they contain confidential information pertaining to SITF and SPO investigation, the remaining materials do not pertain to SITF and SPO investigation, and the charges in the indictment do not encompass the dissemination of such materials by the accused. As such, the SPO has no objections to the reclassification of this material as public. It is highlighted, however, for the trial panel consideration of the opportunity to publish this item on the website of the Kosovo Specialist Chambers that not all of the public judgments contained in batch 2 are available in the same format on open sources. In particular, it is noted that the practice of Kosovo courts is to apply redactions to public judgments prior to their publication online, for example, by including only the initial of accused persons, although these accused have been tried in the course of public trials, or only the initials of witnesses, although these witnesses publicly testified in public proceedings. So the SPO submits that the materials included in batch 2 should not be uploaded in this format on the KSC website in order to mirror the policy on online publication of the Kosovo courts that issued these public judgments. Moving to category 5, these are excerpts of batch 3. These categories includes all items, including in the range from P106 to P119 and MFI. All the disclosed pages of batch 3 have been authenticated by W04841 in the course of our testimony, and both the relevance and probative value appear evident as they are excerpts of the confidential materials that have been disclosed by the accused on the 22nd of September 2020 and that have been handed over to the SPO on the same day. As previously submitted, and mindful of the trial panel decision F00350 paragraph 18, the SPO submits that the classification should remain confidential as these are confidential materials disseminated without authorization by the accused. Category 6 includes one item only. It's P126 MFI, and it is a letter from an international organization received by the SPO. The origin of this document appears clear based on the layout and content of the document itself. In addition, the SPO is the recipient of such correspondence, which is part of the SPO official records, as confirmed by W04841, who authenticated this letter. This correspondence is relevant as it explains the framework of the cooperation between the SPO and this international provider, and in particular the regime of confidentiality imposed on materials obtained by the SPO from this provider. The document corroborates W04841's testimony that certain information included in batch 3 was subject to confidentiality and use restrictions imposed by third parties. The letter has been classified as confidential by the international provider itself, as it is apparent on the face of the document, and the SPO requests that such classification be maintained. Category 7, these are public filings of the Kosovo Specialist Chambers referred to in the course of W04841's testimony. All these items have been addressed in the course of the witness testimony in relation to protected information contained in batch 3, as submitted by the SPO with the filing F00357. The dates and contents of publicly available court records of the Kosovo Specialist Chambers are judicially noticeable. Should the trial panel consider necessary that these filings be also tendered for admission in order to be relied upon in the present proceedings, the SPO requests, in the alternative, that these public court records be formally admitted into evidence in the framework of the present proceedings, and the classification of these items is public. In relation to category 8, associated exhibits, first, there are some items which have been addressed with the W04841 in the course of their testimony shown to the witnesses, and these are items 46 and 45 on the SPO exhibit lists, and in particular items with year and number 081381 to 081391 and 081381 to 081383 ET revised. W04841 referred to this press article and its translation in her declaration P86. The admission of this press article has already been requested by the SPO under Rule 154, among other associated exhibits. Should the panel require that this request for admission be reiterated for this item individually, I hereby do so. This item has also been addressed in the course of the witness examination, and she authenticated its origin. The item is relevant and probative as it contains information and images of materials included in batch 3. The classification of the item is confidential in our submission as it contains references and pictures of confidential information included in batch 3. Proposed redactions have been already submitted by the SPO with filing F00324. Identical submissions, Your Honor, apply to items 50 and 51 on the SPO exhibit list, that is, press article with the year and number 081395 to 081404, and the English translation 081395 081398 ET. So I will not repeat the submissions, which are identical in terms of relevance and authenticity, probative value, and classification. And the same submissions also apply to items 55 and 56 on the SPO exhibit list, that is, items 081414 to 081415 ET, and 081414, 081422. The next item is SITF 0037 to 142 to 0037 to 153. The witness has W04841 has expressly referred to this order in her declaration with the MFI number P86. Its submission has been already requested by the SPO under Rule 154 as an associated exhibit to that declaration. Should the panel require an individualized request for admission of this item, I hereby request the admission of this item. It has been addressed in the course of the witness examination who authenticated it. It's relevant as it is exemplificative of the information relied upon by W04841 when addressing protective measures relevant to witnesses referred to by name and pseudonym in batch 3. The classification of these items should remain confidential, as the link between a specific court order on protective measure issued by Kosovo courts in a specific case and batch 3 increases the risk of identification of SPO witnesses and potential witnesses mentioned in batch 3. There are then 3 more items identified by the trial panel, 2 more items as exhibits not shown by the witness, but which she specifically confirmed that she reviewed. I note that within this category, actually, also items 52 to 54 on the SPO exhibit list should be included, as the witness specifically confirmed to have reviewed these items during her testimony of the 19th of October 2021, and it is page 980 of the transcript. For all these items, the submissions are the same, and I will just mention which items I am referring to. These are items 47, 49 on the SPO exhibit list, in particular the video clip 08139201, as well as its English transcript and Albanian transcript, and items 57, 59 on the SPO exhibit list, referring to the video clip 08142201, as well as the English transcripts and Albanian transcripts. And finally, the video with ERN 08140501, including the English transcripts and Albanian transcripts corresponding to items 52 to 54 on the SPO exhibit list. All these videos have been expressly referred to in the declaration of W04841 with MFI P86, and the authenticity and relevance of these materials has been contextualized by the witness both in her declaration and in the course of her testimony. These are all videos that contains information and images of materials included in batch 3. The classification for all these items should be confidential, and the SPO has already submitted proposed redactions with the filing F00324 Annex 1. Finally, there is a last item, which is an exhibit associated to the witness declaration with the MFI P88, and this is item 078981 to 078982, and its English translation. These are pages included in batch 4 that W04841 identified in her written declaration as being of a different nature than the confidential materials included in batch 4. These 2 pages have been disclosed, and W04841 expressly refer to these particular pages in P88 MFI. For this reason, its submission has been requested by the SPO under Rule 104, I reiterate, if necessary, a request for admission of these two specific items. And the document has been authenticated by the witness and is relevant because it provides the context and makes intelligible the information included in the witness declaration and is part of the materials that the SPO received from Gazzetta in Focus. The classification of this item can be public. Thank you, Your Honor.
Judge Gaynor had a question or two.
Thank you very much, Mr. President. Ms. Bellici, just a reminder about the proposed redactions. As the presiding judge pointed out at the start of this trial, this is a public trial. The accused are entitled to a public trial. And one aspect of a public trial is that all exhibits admitted are accessible to the public. So I would remind you, in respect of proposed redactions, to keep those redactions to the absolute minimum. Is that all right?
No, for the reduction that have already been submitted, we would maintain that these are the proposed reductions that we would submit to the attention of the trial panel.
Very well.
Yeah.
Just a couple of questions about category 4,
Yeah.
which is batch 2.
Yeah.
Now, in your submissions today, you reminded us that besides the 6 pages, which are fully redacted, the rest of P104 MFI, which is batch 2, can be admitted as a public document.
Yes.
Right. So, just very briefly, and you don't have to answer it now if you're not prepared, setting aside the 6 fully redacted pages, what crime precisely has been committed by the public release of the rest of batch 2?
The indictment does not encompass the remaining parts of batch 2, it's very clear.
So the crime focuses on the 6 fully redacted pages of batch 2, is that correct?
The indictment refers to dissemination of confidential materials on the 16th of September. Batch 2 is the materials that the SPO manages to seize on the 17th of September.
Right. So the criminal, insofar as a crime has been committed, the essence of the crime is about those 6 pages. Is that right?
The 6 pages are the materials that the SPO managed to recover. There is information based on the press conferences and the declarations of the accused that the materials that have been distributed to the press and the public exceed the materials that were in fact recovered by the SPO on the following day.
Okay, the concern that I have is that neither the trial panel nor the defense are able to inspect those 6 fully redacted pages. And those are the very pages which constitute the essence of the crime insofar as you are able to present evidence of that crime.
The 6 pages have been addressed in W04841 declarations, and the contents of these 6 pages have been reiterated in the course of our testimony before this trial panel. The 6 pages are currently subject to a protective measure order issued by the pretrial judge.
Right, so that brings me very, very neatly, thank you very much, to the core of the issue. And that is that those 6 pages on their own obviously have no probative value. 6 pages of black ink have no probative value, they have no relevance. So the trial panel is left with the evidence of witness Pumper about those 6 pages. Mm-hmm. Is that correct?
The trial panel has the 6 pages in the sense that these are part of the records that have been submitted to the pretrial judge when protective measures have been requested.
Let me make our position absolutely clear on that. The 6 unredacted pages are not admitted in evidence. They have not been tendered by the SPO. They have not been admitted in evidence. They form no part of the trial record. So this panel cannot rely on the unredacted versions of those 6 pages. Do you fully understand that?
I understand it, and the way how the information concerning the contents of these 6 pages has been presented is through the testimony of the witness who has reviewed these 6 pages, reported on that, and confirmed the contents of these 6 pages before this trial panel.
Very well.
Interpreters kindly ask the speaker, Mrs. Bolici, to speak into the microphone. Thank you very much.
Could I ask you to turn your attention to the concept of judicial notice? Now, judicial notice under the rules of procedure and evidence encompass either the judicial notice of adjudicated facts or the judicial notice of facts of common knowledge. And here, the SPO has submitted that the items which you say are judicially noticeable are judicially noticeable as facts of common knowledge. Isn't that correct?
As a filing of this court, as public accessible filings of this court.
Now, is there anything to distinguish publicly accessible filings of this court from any publicly accessible document issued by a ministry or a court in another country? Is there anything which makes the filings of this court more admissible as facts of common knowledge than the filings of any other public entity in the world?
To start with, the authenticity of the filings of this court is hardly in question, I believe, but the relevance of this filing has been shown through the testimony of W04841. She relied on these filings in relation to the information she provided on confidential materials included in batch 3. Should there be a need for a formal request for admission of these specific filings as relevant to W04841's testimony, we are ready to make this request. In fact, I already made it.
Yes, we've noted that as an alternative. You sought the admission of the filings as exhibits, and we are actively considering that option. I have no further questions. Thank you, Mr. President. Thanks to you, Ms. Bolici.
All right, Ms. Bolici, 2 things. You did not mention the loan item in category 9, item 1D1. You might want to restate your position on that one.
Yes. The defense has sought to tender this witness interview through the testimony of W04841, who explained she's not competent to speak about these items. So in the SPO's position, the defense has not established the relevance of this item at all. And on this reason, the submission into evidence should be rejected.
And secondly, it is now time for you to read the summaries concerning Ms. Pumper's statements. Bear in mind the translators.
I'll slow down, yeah. So we start with the summary of the declaration with MFI number P86. W04841 states that she reviewed the documents that were seized at the Kosovo Liberation Army War Veterans Association, KLAWVA, on the 8th of September 2020, batch 1. W04841 states that batch 1 includes confidential documents pertaining to investigations of the Special Investigative Task Force, SITF, and Specialist Prosecutor's Office, including names and personal details of witnesses and potential witnesses. W04841 further states that media articles referred to in this declaration reproduce information contained in batch 1. W04841 states that she reviewed the documents that were seized at the KLA War Veterans Association on the 17th of September 2020, batch 2. W04841 states that batch 2 includes 6 pages of confidential documents pertaining to SITF and SPO investigations that are also contained in batch 1. W04841 states that she reviewed the documents that were seized at the KLA War Veterans Association on the 22nd of September 2020, batch 3. W04841 states that batch 3 includes 2 incomplete copies of an SPO confidential document pertaining to SPO investigations, including names of witnesses and potential witnesses. W04841 further states that media publication referred to in this declaration reproduce information contained in batch 3. We'll move now to the declaration dated 9th of February 2021, P88MFI. In this declaration, W04841 provides more detailed information on certain documents not in the English language, which are included in batch 1. We'll move to the declaration dated 17th of February 2021, which is P89MFI. In this declaration, W04841 states that she reviewed the documents that were handed over to the SPO by a media outlet on 9 September 2020, batch 4. W04841 states that the contents of batch 1 and batch 4 largely overlap. W04841 states that she reviewed documents that were sent via email to the SPO by media outlet on the 7th of September 2020. W04841 states that these documents reproduce pages included in batch 1 and or batch 4. We'll move now to the declaration of 7th of May 2020 with MFI number P90. W04841 provides in Annexes 1 and 3 to this declaration detailed information on each of the documents contained in batches 1 and 2 respectively, and in particular the language, type, title, description, and origin author of the document, a list of indicia suggesting the confidentiality of the documents, and whether the document includes names of potential witnesses. W04841 provides in Annexes 2 and 4 to this declaration screenshots of portions of documents contained in batches 1 and 2 respectively, which constitute samples of indicia suggesting the confidentiality, such as logos, stamps, and or apparent markings, and other specific references to confidentiality. W04841 states that batch 3 includes 2 incomplete copies of an SPO confidential document pertaining to SPO investigations, including names of approximately 150 witnesses and potential witnesses. W04841 provides in Annex 5 screenshots of portions of batch 3, which constitute samples of indicia suggesting confidentiality. I will move now to the declaration dated 7th of May 2021 with MFI number P91. W04841 provides in Annex 1 detailed information on each of the confidential documents contained in batch 4, and in particular the language, type, title, description, origin and author of the document, a list of indicia suggesting the confidentiality of each document, whether the document includes names of potential witnesses, and whether the document is also contained in batch 1. W04841 provides in Annex 2 to this declaration screenshots of portion of documents contained in batch 4 which constitute samples of indicia suggesting confidentiality, such as logos, stamps, and/or apparent markings and other specific references to confidentiality. And finally, the signed statement dated 14 of October 2021, which is P87MFI. In this statement, W04841 provides minor corrections and clarifications in relation to previous declarations. Thank you, Your Honor.
Mr. Rees, Ms. Belici used a little extra time, so we will grant you 25 minutes, and the same for you, Mr. Cadman, so that you have about the same amount of time.
I'm grateful. Your Honour, our first submission, primary submission, is that the entirety of Ms. Pumper's testimony, both oral and, to the extent documentary, should be excluded and should not be admitted under Rule 138, Sub-Rule 1. Rule 138, Sub-Rule 1 provides that evidence should not be admitted if its probative value is outweighed by its prejudicial effect. I will rely on Rule 138, and in relation to the documents themselves, make some additional points that, in fact, the ground for admissibility is not established in the first place, namely relevance. In relation to the primary submission, Ms. Pumper was called on behalf of the SPO and testified to effectively summarise the contents of 4 of what's been described by her as batch 1, 2, 3, and 4, the vast majority of which have not been produced, the documents themselves, in evidence, so the trial panel does not have access to the documents to make assessments itself, nor the defence able to scrutinise Ms. Pumper's assertions as to their contents. She was called to and has summarised the contents of those documents. The act of summarising documents necessarily entails the giving of opinions and conclusions on the contents of those documents. That's a reference to the case of Prosecutor and Perisic. The trial panel has the reference previously in an earlier filing, which I will ask the trial panel to look back at F00317. Not only has Ms. Pumper summarised the content, she has an act of which involves making decisions on which features of the document to report. That is an act of selection. It involves drawing conclusions by the witness as to what she thought was relevant to bring to the trial panel's attention, and with little consideration as to what else might be relevant, and I'll come on to that in due course. And indeed, she has gone so far not only as to describe the contents, but also to make assertions as to the conclusion, namely, as concisely summarised by Ms. Belici moments ago, she has repeatedly stated that the batches that have not been produced for court contain confidential information. That is a drawing of a conclusion on the documents. She is an investigator of the prosecuting party. She is not, in our submission, entitled to present opinions or draw conclusions on those contents. They are documents with which she has familiarised herself only by virtue of having reviewed them in the context of a discrete task at the request of the prosecutor for this case. She made that clear. She'd never seen or had any relationship with the documents before that. And we rely again on Prosecutor and Perisic for support for the proposition that she cannot draw conclusions on documents in those circumstances. And we submit that where a summary of this nature is prepared by an employee of the party who seeks to rely upon it, that summary should not be regarded as reliable unless the material itself is in evidence, so the trial panel may make its own assessment of the material. Were the trial panel to rely upon the summary without having the opportunity to make its own assessment of its reliability, the public perception of a verdict based upon that summary would be that the verdict is unsafe. Those are the words of the appeals chamber in the case of Prosecutor Milosevic. The reference set out a footnote 7 to filing F00317. And we submit that that is the situation that the court finds itself in, being presented with the evidence of Ms. Pumper. It is not an independent assessment. The documents should have been produced by the prosecution for the trial panel to review and assess itself. The assertions of her as to the contents of batches 1, 2, and 3 and 4 are not accepted as accurate and reliable. In the absence of disclosure of them and production of the documents itself, her assertions are have no greater probative value than assertions made by Ms. Bellici on behalf of the prosecution as to their contents. Indeed, we know now that in fact, her declarations were produced at the request of and with significant input by the prosecutor herself, indeed. In relation to her very limited review of the documents, not only are we unable to challenge her assertions as to the contents of the documents, we are unable to do any of the other checks that may have been relevant, which the witness did not consider making and did not. So, for example, she accepts now she undertook no checks of the authority of named persons to designate documents as confidential. She was not aware when she undertook the review that authenticity of the documents was an issue, and she was candid enough to accept that it cannot be said that there has been a complete review of authenticity. She said that at transcript page 1069. She made it clear that her testimony does not set out any reporting on the exclusion of persons who were dead or provided negative information during the course of the review. She undertook no checks as to whether names included by her in her charts as witnesses or potential witnesses had been publicly identified by, for example, the Serbian authorities, or by other courts, or by the witnesses themselves. References the transcript page 1089, page 1313, page 1315, page 1316 to 1321, and 1326. She undertook no background checks on any of the names that she reports upon, such that the defence cannot explore the issue of public interest in relation to those names further. The reference to the transcript is page 1098 and 1099. She undertook no checks as to whether any of the orders or petitions or requests which the witness asserted lent a quality of confidentiality to undisclosed names had been subsequently amended or rescinded or altered. The reference to the transcript is page 1333. She took no checks, even the most simple checks, with dates of letters from international organisations which the witness asserted lent a quality of confidentiality to undisclosed names, to consider whether, for example, they pre- or post-dated events in September 2020. Reference to that transcript, that page of the transcript is page 1338. And again on the same page, of the transcript, she accepted she had undertaken no checks as to whether any of the letters from international organisations, which she asserted lent a quality of confidentiality to undisclosed names, if they predated September 2020, whether they'd been subject to any subsequent amendment or waiver by those organisations. In the absence of disclosure of the documents, the names, such letters from international organisations, for example, those checks cannot be undertaken by the defence, and the trial panel is left in the position, as we assert, that the SPO are asking the trial panel to simply accept the assertions of the witness that the batches contained confidential information without scrutiny or question. So our primary submission is that the evidence of Ms. Pumper in its entirety should be excluded, should not be admitted. Its probative value is outweighed by its prejudicial effect in the circumstances. In relation to the specific documents, we object to the declarations and the official note of the witness. The submissions that we make in relation to her oral testimony, in relation to the unfairness of admitting her evidence, summarising documents that have not been produced as exhibits for the court, apply equally to the declarations in writing. Additionally, of course, if her oral evidence is admitted, we would submit that in those circumstances there's little point in admitting the declarations as an exhibit as well. It's not as if the SPO sought to admit the declarations under Rule 154 and then effectively tendered the witness for cross-examination. She was examined, direct examination, for some 2 days, going over the matters that are set out in the declarations. So we submit that it would be, it's inappropriate in those circumstances to adduce the declarations that are effectively repetitive of her direct evidence. Moreover, they contain, of course, the annexes that she produces. Again, the submissions we make about the unfairness of her oral testimony in general apply to the proposed admission of those annexes. We note as well that despite their length, the SPO, during the course of the 2 days of direct examination with her, did not, frankly, seek to explore those charts or go through them with the witness in any detail whatsoever. So we say additionally, the submission, or rather the admission of those lengthy annexes, where the witness has been in direct examination for 2 days without any attempt to address those lengthy annexes, is unfair.
Lidhur me dokumentin punën 38 MFI.
Properly can be admitted, already has been at P98.1. The remainder of that official note deals with matters which are outside the knowledge, direct knowledge of this witness. And the court has already ruled that official notes, that the evidence of a witness should deal with matters that are within their knowledge. The contents of that official note are not. In relation to the Category 2, excerpts of Batch 1, well, those are documents which we have seen. They are asserted to have come from the documents that the witness labels as Batch 1. but we do raise the issue of continuity, which we have raised previously in the filing F00317. We raised at that stage that the SPO did not appear to intend to call evidence to prove the origin, the provenance, and the chain of custody of batches 1, 2, 3, or 4, noting that in the declarations of Ms. Pumper, they had been described in informal shorthand rather than being given a formal exhibit number identified upon a sealed evidence bag, securing contents from interference with a log produced which records the date, time, and identity of the officer whenever the bag has been opened and the contents accessed before being resealed. So the SPO cannot claim that they were not put on notice that continuity was an issue in the case. And as far as Ms. Pumper, in her oral evidence went, was to assert that the documents that she then labelled as batches 1, 2, 3, or 4 came from evidence bags. She gave no detail as to those evidence bags. She gave no evidence bag number from which the documents came. I am aware that the SPO seeks to call, there's an application outstanding to add another witness to the witness list that might deal with the seizure of the documents in the first instance, or at least in some of those documents, in a way that is fuller than the sole documentary record which the trial panel does have in evidence, which, as we've looked at, describes documents being seized in the most general of terms, giving no indication as to the number, and certainly no assistance with, for example, the number of an evidence bag in which those documents were put into. But Ms. Pumper's evidence has concluded whatever the witness who's subject to the request which is objected to, but whatever that witness might be able to say, Ms. Pumper's evidence has concluded, and she has not assisted the court with giving any greater detail as to where the documents that she refers to as batches 1, 2, 3, or 4 came from, and in particular what evidence bag, if they were indeed placed in any such bag. So, in relation to the excerpts of batch 1, and indeed batches 2 and 3, we make the same point, that there is no proper evidence of continuity, and the relevance of those exhibits in the circumstances is therefore not established in the first instance. In relation to category 3, and official notes on the receipt of material from the media, items P99 MFI and P101 MFI are authored by 2 other SPO officers, and they record events with which this witness was not involved. And despite the trial panel's reminder only moments before we turned to deal with the admissibility of these matters as to how they expected the SPO to address notes, official notes, they again seek to adduce a note, the substance of which effectively is a witness statement from a witness who is authored by a witness who is not being called to give evidence, the contents of which the present witness, Ms. Pumper, cannot give evidence as to the truth and accuracy of their contents. The same position relates to P102 MFI. In relation to category 6, correspondence from an international organisation, we certainly in relation to the first document, the relevance of it is entirely unclear in the sense that it postdates by, I think, 6 months the events with which we are concerned. The other correspondence, we submit the relevance of those letters has not been established. in the absence of the document in evidence which any such letter is alleged to have lent confidentiality. So we understood the purpose of referring to those letters was for the witness, Miss Pumper, to say letter A establishes or lends a quality of confidentiality to the material or information found in document B. We understood the purpose, but in the absence of production in evidence of document B, in that example, letter A has no established relevance, and we submit they should be excluded for those reasons. We do not consider that filings are judicially noticeable. We think that that is a misuse of the principle which allows a court to take into account matters judicial notice. If they are to be relied upon, they should be properly admitted as exhibits. And in relation to category 8, the associated exhibits, to the extent that any such press articles were referred to in evidence, if the evidence of Miss Pumper, her oral testimony, is not excluded, we have no great objection to those items referred to in evidence being exhibited, but we do not think, we submit that the exhibits that were not referred to the witness should not be. Finally, in relation to category 9, the item we tendered, the interview, of course, is a document that's been disclosed to us by the SPO. It's prepared by the SPO. It was shown to the witness. We did ask for it to be tendered. If there is an objection to that, we will look to address its admissibility at a later stage in the trial when we address the admissibility of other potential defence exhibits. We are conscious that at an earlier stage in the proceedings, the trial panel encouraged the parties to consider the use of bar table motions as part of their case, and we are considering that direction, and such an application may well follow in due course.
We have about 20 minutes. Is that going to be sufficient for you, or do you wish to have more?
On the basis of the ground that's already been covered by Mr. Rees, I certainly don't want to go over what he's already covered. What I can say as far as category 1 is concerned, I adopt Mr. Rees's submissions as far as the totality of Ms. Pumper's evidence. That is a position which is shared by the defence for Mr. Haradinaj for the same reasons that Mr. Rees has already set out, and I don't need to repeat. On the basis of the declarations, sorry, I was just searching for the word, not statements, but the declarations that she has made. And as Mr. Rees has quite clearly stated, she's given lengthy evidence in both chief for 2 days and further cross-examined for a number of days, so it's unclear on what basis, as Mr. Rees has already set out, those official notes and declarations ought to be admitted. I mean, her evidence is what she gave on the stand, both in chief and cross-examination. I would also state that the declarations are in part meaningless in the areas where she seeks to comment on a significant number of matters that she cannot possibly give evidence upon, as she was not present, and they refer to declarations of other persons who may or may not be called. As we've heard, one request for an additional prosecution witness, another SPO officer, has been made, and we will obviously respond to that in due course by the end of today as to whether that witness should be called. But there are significant concerns that much of the material that the prosecution is seeking to admit falls outside of her knowledge and should not be admitted on that basis. One of the points that Mr. Rees has set out in detail, which is shared by the Haradinaj defence, Mr. Rees has set out in detail the question of continuity and the effect of chain of custody. Now, as far as the excerpts from the batches are concerned, chain of custody is a real issue. Mr. Rees has referred to the absence of anything being put in evidence by Ms. Pumper that establishes continuity. We have set out previously, and I say it now, given the lack of a seizure list, a detailed breakdown of what was recovered, there's no basis upon which we can be certain that the documents that formed part of the batches are therefore, as much as they are what they purport to be, they aren't necessarily evidence of being within the batches. What we have not heard is evidence to confirm that the material that has been scrutinised or reviewed by Ms. Pumper is the same material that purports to have been seized from the WVA. And so I stress that the chain of custody remains a real issue. In respect of Category 3, P99 MFI, certainly that's a matter that may or may not be presented by the additional witness that the SPO is now seeking to call. Ms. Pumper is not the author of this note and therefore should not be entitled and cannot adduce the exhibit. To enable the exhibit to be admitted, the individual who authored that note ought to present it and give evidence concerning its contents. And we've heard that both in respect of the witness that they may call, but there is also further declarations by other SPO officers who the SPO are not seeking to call. The panel's previously ruled in respect of the other contact notes, and yet the response of the SPO is not to call those witnesses. Again, only one. This is for reasons only known to the SPO, but regardless, further efforts to try and circumvent ordinarily accepted rules of evidence ought to be resisted. In terms of Category 4, dealing with Batch 2, I would merely just state that that is the same issues in respect of chain of custody and provenance. In respect of Category 5, Batch 3, I won't say anything further than what Mr. Rees has already said. I merely join his submissions in that regard. Category 6, Mr. Rees has set out the relevance test that is not met in respect of this document. And then in respect of Category 7, we've already heard whether these are documents that should be considered judicially noticeable. In respect of Category 8, the associated exhibits, again, I don't feel it necessary to go over ground already covered by Mr. Rees, and certainly in respect of Category 9, which relates to two items referred to by Mr. Rees. Again, you've heard his position on that, and I don't feel as though I can add anything that would, anything further that Mr. Rees hasn't already said in his submissions.
Thank you, Mr. Cadman. We're a little early, but we will break for the morning break before beginning with the testimony of the next witness. Be back here at 11:30. We are adjourned.
Rise. All right.
Be seated. Mr. Cadman.
Your Honours, I just wanted to raise something with the court before the witness is brought in. It's got nothing to do with the witness. Your Honours will be aware that inter partes communications in this case have been far from optimal. Following the matter that I raised with the court earlier this week in relation to the additional expert, I communicated to the SBO the documents certainly that we intended to put to the witness, the expert, for him to consider, with a request that they indicate whether they had any objections to those documents or whether they had any documents that they would like to be added based on the previous objections they'd made to the first expert. The regrettable response that we have received is that they take no position at this time, so I am compelled to proceed on the basis of having no input from the SBO. I just wanted to put that on the record.
Thank you, Mr. Cadman. It is on the record. Mr. Potch?
Just briefly, Your Honour, that is correct in terms of our response. I note that the SPO was not even heard as to whether the expert should be instructed. We would have objected, given the opportunity. And more importantly, of course, the expert is not going to be a joint proposed expert. It is a defense expert. So we thought it inappropriate at this stage to propose material to be provided to that person. Once that expert is instructed, we, of course, reserve our position pursuant to rules to object on the basis of the reports, including what material has or has not been provided. Thank you.
Thank you. All right, we can now continue in the presentation of the evidence. Madam Court Usher, please bring the witness in. Good afternoon. Good morning, Mr. Jukic. The court usher will provide you with the text of the solemn declaration which you were asked to take pursuant to Rule 141, Paragraph 2 of the rules. And you can please proceed to read it.
Conscious of the significance of my testimony and my legal responsibility, I solemnly declare that I will tell the truth, the whole truth, and nothing but truth, and that I shall not withhold anything which has come to my knowledge.
Thank you, Mr. Jukic. You can now take your seat.
Thank you, Your Honor.
Mr. Jukic, today we will start your testimony, which is expected to last up to 3 days. As you may know, the prosecution will be asking you questions first, and once they're done, the defense has the right to cross-examine you, and then members of the panel may have some questions for you as well. The prosecution estimate for your examination is 4 hours. The defense estimate is 2 days. The panel may allow redirect examination by the SPO if conditions for it are met. Please try to answer the questions directly and clearly with short sentences. If you don't understand a question, feel free to ask the counsel to repeat the question or to tell them you don't understand, and then they will clarify. Also, please try to indicate the basis of your knowledge and facts and circumstances that you will be asked about. Please also speak into the microphone and wait 5 seconds before answering a question, and speak at a slow pace for the interpreters to catch up with you. During the next days while you are giving evidence in this court, you are not allowed to discuss with anyone the content of your testimony. If any person asks you questions outside this court about your testimony, please let us know. Mr. Prosecutor, you may begin.
Thank you, Your Honor. Good morning, Mr. Witness.
Good morning, Mr. Prosecutor.
We know each other, but I'm going to start by asking you some questions to establish your identity and background for the court. What is your name?
My name is Miro Jukic.
What is your date of birth?
4th of December 1971.
What is your nationality?
I'm Croatian.
What is your level of education?
I'm Bachelor of Law.
And where are you currently employed?
I'm currently employed in the Specialist Prosecutor Office.
And how long have you been employed with the Specialist Prosecutor's Office?
I'm employed since September 2019.
And what is your current position with the SPO?
I'm a Witness Security and Handling Team Leader in Specialist Prosecutor Office.
And how long have you occupied this specific position?
From April this year.
And before you took on this current role, what was your role within the office?
I was Witness Security Officer in the Specialist Prosecutor Office.
Could you provide a general outline of your duties and responsibilities in your current role?
Yes. I'm advisor of Deputy Specialist Prosecutor and head of unit for operational and witness security unit in all witness security related matters, administrative and operational for the witnesses Specialist Prosecutor Office is responsible for.
And could you tell us a little bit about your duties in your prior role with the SPO when you were a witness security officer?
Yeah. Our role as a witness security officer was a direct contact with the witnesses, with all the witnesses who are with Specialist Prosecutor Office is responsible for, keep contact with them and maintains all their needs and meetings with the prosecutors and Specialist Prosecutor Office.
And do you still have direct contact with witnesses in your current role?
Yes, I do.
And before you started your work with the SPO, could you tell us whether you carried out work of a similar nature to that you carry out within the SPO?
Yeah, last 20 years I'm working in the field of witness protection.
Could the counsel and the witness slow down, please? Could they pause between question and answer? And please do not forget the interpreters. This pace is really very, very fast. Thank you very much.
I've been told to slow down, and I'll do my best to do so.
I won't add anything to that. It was quite complete.
Okay.
And Mr. Witness, I had asked you about your experience, if you had experience of a similar nature to that within the SPO before you started your work with the SPO.
The last 20 years I'm working in the field of witness protection, witness security and victim support. I was working nationally and internationally in the Balkan area, in Croatia and Bosnia. Before I joined to the SPO, I worked 6 years for ICTY as a witness protection officer / support officer, victim support officer.
And am I correct in understanding that the work you just described with these other entities is similar in nature to that you carried out with the SPO?
Yes, I worked for the Croatian Ministry of Interior and I worked for International Tribunal for former Yugoslavia.
And were your duties and responsibilities similar in nature to those you carry out with this office, the SPO?
Yes, especially during work for International Tribunal for former Yugoslavia. I was protection officer responsible for the all protected witnesses. I was engaged in the work with the victims, victim support, and all their needs.
Do you recall providing a declaration to the SPO in October 2020? and later an addendum to this declaration in January 2021?
Yes, I do.
I'm going to ask you some general questions about the October 2020 declaration, so the first one. First of all, could you briefly tell us what this first October 2020 declaration was about in general terms?
In general terms, that declaration was about my contacts with the witnesses after the SPO document leaked in and published in the public.
And you said it was about your contacts with witnesses. Did it include information about contacts by other persons with witnesses in the same context you just referred to?
Yes, there was also several official notes I reviewed from contacts from the other colleagues, prosecutors, witness security officers, and investigators.
And in general terms, what about this contact yourself and other persons had was reported in this declaration?
So after the leak, the document leak, we received several phone calls from the witnesses who were concerned, scared about the fact that their name is published in the media in Kosovo and the region. We decided to call some of them to inform them that their name is in the leak, in the public document, and all my knowledge and all written in declaration was about the contact with those people.
And then, do I understand correctly that the declaration reflects information obtained during these contacts you just described?
Yes.
You mentioned concerns and persons feeling scared during such contact. And you also mentioned that persons contacted us. Was that by phone, that persons contacted the office?
Yes, several witnesses contacted because usually our procedure is after the interview of the witness, we provide them with the phone number that in the case they need to contact SPO. So usually that phone numbers are phone numbers for witness security phone numbers, and that's the way how witness can contact us.
When this phone number is provided to witnesses, is it specified that this is the number to contact in case of security-related matters, to your knowledge?
It is for all SPO-related matters.
And you mentioned that other than witnesses contacting the SPO then also contacted witnesses, and how was that done?
After the leak, 22nd of December, when we find out about documents which published, we decide to see the list, to go through the document and identify all the names in the leak. After we identify all the names, we went through the list and identify all the victims and the cooperative witnesses, and we decide to call them and inform them about the leak. We thought that in that moment we are obliged to inform the people who gave the statement and who cooperate with SPO, that we are obliged to inform them that their name become public.
I believe you referred to the 22nd of December in your response. Do you know if that's correct or whether the information...
September, sorry.
Yes. And just for clarity's sake, when you're referring to this documents being made public, is that you're referring to the instances of the press conferences by the KLA War Veterans Association?
Yes, I do.
You mentioned that among the persons contacted were victims. Could you give a little bit more clarity what you mean when you say victims?
We have several categories of the witnesses, and one of the category are victims who, by our SPO opinion, are mistreated, beaten, or tortured in any way from any person during the period of our mandate in Kosovo.
And you also mentioned the concept of cooperative witnesses. Could you clarify what you mean by that in this context?
We mean about every witness who was summoned by SPO and gave the statement to the SPO.
And the persons that you contact, was that contact by phone, in person, or both?
Most of them, they were contacted by phone. Some of them, if they insist, we met personally. And some of them, because we couldn't reach them on the phones, we went to their homes and houses to meet them in person.
In relation to the telephone contacts that the office made to these persons, could you tell us how you obtained the relevant telephone numbers?
So we got relevant phone numbers from public sources in Kosovo and also from the witnesses during their interview. They provide us with the phone numbers.
So,
Excuse me, Mr. Rees.
Your Honour, earlier today you reminded the prosecution that it would be important with this witness to identify what matters are within his knowledge. At the moment, there's no attempt to be specific in the questions, and the witness is answering. The question is put in terms of you, and the witness is responding by we, and I make no criticism of the witness of that, but it would follow that the question should be more specific, following the guidance the trial panel has given the prosecution earlier this morning. I ask for some attention to be given to that, please.
Okay, we have to be careful with names and whatnot also, so we're going to have to use some sort of general terms for these witnesses or victims, but he can...
But at the moment, the questions are being, as I understand it, general questions about the office.
Yes.
And as I understood the trial panel's guidance, the prosecution were to make clear in their examination of this witness what matters are within his knowledge, and his actions, his conduct.
Understood.
And if they seek to refer to other matters of the office, to make clear what is within his knowledge and when they're dealing with other matters that aren't.
Accepted. Try to couch your questions in those terms so that we're clear what you're asking about.
Certainly, Your Honour. And Mr. Witness, perhaps just to clarify, when you were talking, for example, about the persons the identification of names of victims and cooperative witnesses, were you yourself involved in a process of identification of whom to contact?
I was involved in that process in the role of the witness security officer. When I answered we, I was referred to the witness security officers because I'm not the only one witness security officer in the Specialist Prosecutor Office.
And in relation to the telephone contacts, did you yourself make any such contacts that you described earlier?
Yes, I did.
And when you made such contacts, you were telling us that you had obtained certain numbers during interviews, for example. So am I correct in understanding that the witness would have provided this as the number on which to call them, and then that is what you used at a later stage last year?
After the interview, witness security officers always had a kind of interview with the witness, obtain all relevant information for witness security, like home address and the phone numbers, and also phone numbers in the case that we can't reach the witness that we can contact.
And were these among the numbers that you yourself and your colleagues used to contact the witnesses after the documents were made public in September last year?
Yes, we used that numbers to contact them.
You told us that you were one of the persons making these contacts. If you recall, could you give us a rough idea of how many such calls you made related to this incident or these incidents in September 2020?
I would say around 30, and I met maybe 10 people.
And do you know, you mentioned that other witness security officers were involved. Were they also involved in making the calls or the meetings with these persons?
Yes, they did involved in both.
Were lawyers working for the SPO involved in this exercise?
Yes, they did.
Investigators?
Yes.
And did you use interpreters or language assistants of any kind?
We used the interpreters in every call.
You gave us an idea about the number of calls and meetings that you were involved in. Could you give us a rough idea, if you know, of how many calls were made by all SPO staff as part of this specific exercise?
Yeah, we did around 200 phone calls.
Where contacts with witnesses for the purposes of this exercise we're discussing, be they over the phone or in person, documented or recorded in any way?
We documented them in the official notes after the phone calls.
And what was the purpose of documenting them in official notes? Why did you do that?
It is our procedure. Every contact with the witness, we record.
And you're using we again. I understand that, of course, to mean you.
Okay.
And who else are you referring to in this case?
I'm referring to the witness security officers and also to the lawyers, investigators. So in our office, every contact with the witness must be recorded and submitted in the evidence.
And do you know what such notes were used for, if anything?
For example, now they are used for this case.
Was there any other reason why the notes were recorded for this exercise?
Yeah, of course, it's very, very important for us that we have track of all our contacts with the witnesses in the preparations for the trials and the preparations to make decision if we invite them as the witnesses or not.
And who, if anyone, would review such notes? And again, we're talking about notes recorded in this exercise we described earlier.
A witness security team leader will review that notes, and the deputy specialist prosecutor.
And were there ever any discussions or meetings about these notes with the security team leader or the deputy specialist prosecutor, to your knowledge?
We had a lot of discussions about notes because what we noticed, there was a lot of people who expressed their fears, and a lot of people, they felt threatened after the publishing of the documents and their names. So we had discussion in general, what we will do, how we will proceed, which measures and actions we will take.
Was this exercise that you just described about contacting the persons named in the documents in any way planned or foreseen by yourself or by the SPO?
Yes, we had a plan.
But when you had a plan, when did the plan come into place? Was it after the documents were provided? When did this start?
So our plan, we first had a plan after the leak to call the people. So we started with the phone calls 24th of September. And we split in several groups. Witness security officers. It was usually witness security officer, lawyer or investigator, and language assistant in one call. So we had 3 persons in one call, if that was possible.
And was this exercise that you're describing and have been describing today a priority for the office at the time once it started?
That was the most higher priority for the office in that time.
And when you say a priority for the office, was that a high priority for you in your role and your team, or also for others, if you know?
It was the highest priority for all office.
And were you in any way involved in planning or organizing this exercise?
No, in that time I was just involved in phone calls.
And who would have been supervising the exercise at the time?
Witness security and handling team leader who was in that time.
And when this exercise started in September last year, do you happen to recall whether staff members in the SPO were mostly at the office or most of them were working from home?
No, we're mostly working from the home.
And do you know whether, because of this exercise, any persons were obliged to come into the office to do this work necessary for it?
There were some persons obliged to come in the office in that time.
How would you describe this exercise in terms of intensity or time consumption?
It was actually I was all the time involved in this exercise.
Did you have time to conduct the work that you had planned other than this exercise?
Not really.
Do you know if others in your same position at the time, witness security officers, had the same issue, that this was taking up all their time?
This was taking all the time for all witness security officers and for the most investigators and the lawyers.
And could you tell us how the names of the persons that the SPO contacted as part of this exercise were treated by the SPO in terms of confidentiality?
We always, for our office, witness security is top priority. We know and we learn that without witnesses, we don't have cases. And the names of the witnesses are the highest priority for witness security officers, for me, and for our office.
So, for example, would you divulge the name of the persons that you were contacting through an unsecure means of communication or not?
We always try to call and contact them through secure means of the communications.
And when, for example, you were told to contact this or that person, was the name and contact information of that person provided to you through secure means or not?
All the names were provided through secure means.
I'd like to focus a little bit on the contacts you were involved in yourself. Could you tell us in general how long these contacts lasted?
Depends. I mean, you are asking about every single call, or you are thinking about all process?
I'm asking in general. For example, one phone call, would that generally last a few minutes, several, or it depended?
Yeah, every call lasted at least 15 minutes.
And in general terms, again, focusing on those contacts you were directly involved in, what was the reaction of the persons you contacted?
So all the persons were very upset. Some of them, they start to scream on the phone. Some of them, they said, don't contact me anymore. And the reaction usually wasn't very pleasant for us.
And these reactions that you just described, what prompted them according to the witnesses and according to what they conveyed to you? What made them feel that way?
They all had a kind of...
The witness can't answer the question, what made them feel that way.
Sustained.
You said that they felt upset and they would scream. Do you recall what information you had provided or what question you had asked which led to that reaction?
Yeah. So we introduced ourselves during the phone calls. Then we would ask if they heard about the leaking of the SPO documents. And then we also informed them that their name is public now, and that was caused them to feel very bad.
So they expressed their concerns after you provided that information?
If we are talking about people who we called, yes.
And how about the people that called you?
Then they started with expressions, immediately after they called, they were very angry.
Did the persons that called you or persons within the SPO state why they were calling in that particular instance?
Yes, they do.
And in general, if you recall, what did they say? Why did they say they were calling you?
They were calling me.
Your Honour, again, can we clarify whether the witness is being asked about contact that he had with the witness, or whether he is being asked about general matters that he
Sustained.
wasn't involved in?
Sustained. You have to clarify the basis for his knowledge.
Certainly, Your Honour. Mr. Witness, let's start from the contacts that persons had with you. First of all, did you receive any phone calls rather than you making any phone calls as part of this exercise?
I received the phone calls before we decide to call and inform all the witnesses.
Could you tell us, in general terms, what the person or persons who contacted you said during that conversation?
I recall that one of them said that he trusts us, and now his name is public, and he and his family are in danger. And he told me that I know very well what happened to the witnesses in Kosovo.
And to be clear, this was a contact from a person before the exercise you described started?
It was contact before.
And do you have any knowledge as to whether your colleagues within the SPO received the same or similar information?
Witness security officers in my office received the same and similar messages or phone calls.
And how do you know that?
Because we had daily meetings as a witness security team, so witness security officers had daily meetings with the witness security and handling team leader.
And could you tell us in general terms what was discussed at such meetings?
In general,
You're right. I do object to this. We're now going into the eliciting of accounts that are second-hand. We've dealt with the bar table motion, and the trial panel has ruled upon that. And I understood that the trial panel permitted in the ruling on the bar table motion limited examination of this witness based on matters that are within his direct knowledge, as opposed to accounts given by other persons of what other persons have said to them.
He was asked about meetings that they held, and I'm not sure where he's going with it yet. I understand your objection at this point. We'll let him continue, and we'll rule on it if necessary.
Mr. Witness, the meetings you're referring to with witness security officers, were you present at those meetings?
There were teams and actually there were phone meetings.
And you attended these phone meetings?
Yes, I did.
So you listened to the information that your colleagues were providing?
Yes, I did.
And you provided information and contributions during these meetings?
Yes, I did.
Could you tell us what information you shared with your colleagues in such meetings, generally speaking?
I shared all information I got from the witnesses during the phone calls or during the exchange of the messages on the phone.
And did your colleagues do the same?
Yes, they did.
You mentioned that persons contacted were upset and they were screaming, for example. Do you recall whether from the contacts you were involved in, all persons said they were scared, or were there some that said they were not scared?
All the persons contacted me, they were scared and upset.
Are you aware whether the information provided by contacted persons, your colleague, was the same? Were there any persons who were not particularly scared or afraid despite what had happened?
All the persons who contacted us, they were scared, and but some of the persons we contacted later during our exercise, they said that they don't care or they are not scared.
Could you tell us whether, as a result of people telling, for example, you or your colleagues that they were scared, the SPO had to take any specific measures or steps in relation to these persons' security or well-being?
SPO made a lot of steps and a lot of measures after this exercise.
Could you tell us in general terms what you're referring to when you talk about a lot of steps and a lot of measures?
So we provide them with some of them we provide with new phone numbers, with phone devices for the safe communication with us. We prepared for a lot of them emergency risk management plans. We also relocate some people from Kosovo.
Let's start with the provision of new phone devices. Am I understanding correctly that the SPO gave new devices to these persons?
For some witnesses who wasn't able to contact us via secure phone conversation via internet, we provide them with the phones for the secure contacts.
And to be clear, was this provided as a result of this exercise, as a result of contact with persons following the disclosures of documents in September 2020?
Yes, it was because of that.
You also mentioned a preparation of a lot of emergency risk management plans. Could you explain to us in general terms what an emergency risk management plan is?
Emergency risk management plan is prepared for the emergency situation that we can extract witness and their family from their homes to the safe place in our office.
And could you tell us what kind of work goes into preparing that plan? Is it you as a security officer who do so, multiple persons?
That was multiple persons, including witness security officers and operational security officers.
You also mentioned relocation. Could you tell us in general terms, without specifying who or where this relocation related to?
All relocation we did were related to the leak, to the witnesses who were scared and they didn't want to stay anymore in their homes.
And how was a decision to relocate a witness due to the leak, as you said, made? What were the factors you considered in making that decision?
The factors are two: threat and the statement, importance of the statement.
Were you personally involved in decisions as to relocation of witnesses related to the documents made public in September 2020?
Yes, I did.
And you mentioned that the two factors are threat and the importance of a statement. When you talk about threat, was that the threat in general terms, the threat communicated to you during the contacts? Could you explain?
In this particular case, that was a threat because of the leak of the document and the name of the witnesses become public.
The interpreters kindly ask the speakers to make a pause between the question and the answer. Thank you very much.
Certainly, my apologies to the interpreters. I'm now going to ask to show the witness a document. And at this stage, I'd also ask to provide the witness with a binder, and this binder contains hard copies of all the documents in the presentation queue. If the court usher could assist, the binder is with our case manager, and it could, of course, be shown to the defense for inspection. And while that's happening, I ask the court officer to call document 084303 to 084303 RED.
Thank you.
Thank you to the court usher, and I see that the document is on everybody's evidence channels. And Mr. Witness, in this binder, you have yellow tabs with numbers on them. And in this particular instance, I'd like you to turn to tab 190. And pursuant to your Honor's instructions, tab 190 means that it's item 190 on the prosecution's exhibit list.
Thank you.
Mr. Witness, can you see this document before you?
Yes, I can.
And do you recognize the document?
I recognize this document.
Do you recognize your signature on this document?
I recognize signature on this document.
We see the SPO logo and the words official note at the top of the document. And then beneath those, we have a table with information such as the date, author, and activity. And then we have some text. Mr. Witness, could you tell us whether this is a standard format for such notes within the SPO?
This is the standard format for the SPO, official notes.
And we also see two different dates in this document. We have the same date at the top left and in the table, and then another date in the text which appears. There's no need to mention the dates, but could you explain what the different dates refer to?
Different dates refer to that because the date when I talked to the witness was date when I was in Kosovo, and the date on the top of the document is date when I was in the office and submit this document in Zylab.
You said that the date in the text is when you were in Kosovo. Do I take that to understand it's the date when the event recorded occurred?
That is date when I called the witness.
Did you ever review notes of other colleagues of yours in the SPO similar to this?
Yes, I did.
And in the context of the exercise we were talking about earlier related to the documents being made public, were these the type of notes also produced by your colleagues in that exercise?
They produced the same or similar kind of the notes.
I'm going to turn to the content of this particular note for a moment. We see in the second and third lines beneath the table that you ask someone whose identity is redacted if he had any security concerns in relation to the recent publication of documents allegedly coming from the SPO. Was this a typical question you asked during such contacts?
There was one of the typical questions we asked during the contacts.
You said it was one of the typical questions we asked during the contacts. Who, in this case, are you referring to as we? You and who else?
I'm referring to me, witness security officers, prosecutors, and investigators who did these calls during the exercise.
And before this exercise, was there any communication between yourself and your colleagues as to how to approach these contacts? For example, what questions to make or what information to provide?
There was a discussion between me, my colleagues, and also instructions from the witness security and handling team leader, which questions and what kind of questions, which information we provide to the witnesses during the phone calls.
And this note, and I'm referring to the lines 4 to 8 in the text, states that after you asked the person about his security concerns in relation to the incident we've been discussing, the person told you he does not feel secure, that there were rumors around his neighborhood that he is an SPO witness, and that this made him feel not safe. Do you recall being provided with information of this nature either during this particular contact or during other contacts you made at the time?
I do.
Your Honors, at this stage I'd like to seek admission of this particular note.
Any objection on this?
can we defer admissibility until after cross-examination?
Because?
I'm very conscious of the ruling that Your Honour gave earlier today on disclosure. I'm also very conscious that Your Honour did make it plain that, of course, if during the course of direct examination matters arose which may lead to a more specific directed disclosure request, that might lead to further disclosure. In the circumstances, I would wish a decision on admissibility to wait. It may be that in due course we take the view that there isn't an objection, and I'll make that clear if that is the case. But can I ask at this stage simply that it's marked as a PFI number?
Your Honour, if I could be heard on this matter.
Yes.
Yes, Your Honour. We have heard no reason to defer admission of this item. The information has been elicited as to its authorship authenticity. The witness has stated he is familiar and recalls the content thereof. Deferring admission of items when there is no good reason is not really conducive to the efficiency of proceedings. It would be ideal to avoid a situation like we had this morning where we had to go back in time and address several items discussed at a time. And of course, any information elicited in cross-examination as to this specific item or anything else the witness has to say would go to the weight, if any, Your Honour's place not on its admissibility.
Thank you, Mr. Pace. Mr. Cadman, do you wish to add anything to this?
Nothing further. I think Mr. Rees has set out what the position is.
All right. There's no objection on the file. There's no objection being made, and the exhibit is proper. And, of course, any statement made goes to the weight of the testimony or the weight of the evidence. So the exhibit will be admitted. Can I have a number, please?
Your Honours, that will be exhibit P130.
P130 is admitted. Go on, Mr. Potch.
I'd like to show... My apologies. I'd like to show another document, and that is 093386 to 093387 RED. And Mr. Witness, this is at tab 354 of the binder in front of you. Can you see the document, Mr. Witness?
Yes, I can.
Do you recognize it?
I recognize this document.
So this note refers at paragraph 4 to you being informed that a person whose name is redacted heard about the leaking of documents the previous day, and this made him very scared, panicked, and worried about his and his family's safety. The note also reports that the person told you that he took his wife, and then we see a reference to driving and the house. And it goes on to say that the person told you he left Kosovo and was scared to go to work. At paragraph 6, the note refers to you receiving a message from this person referring to leaked documents being all over Albanian media. Do you recall being provided with the information reported in this note?
Yes, I do.
And during your own interactions, such as this one and other calls and meetings in the context of the exercise referred to earlier, did you get the impression from the persons you were in contact with that they were aware of what had happened in relation to the documents in September 2020?
This particular person was very scared from the moment when was published first document. from KLA War Veterans Association.
And earlier you told us that some persons contacted the office themselves, and those persons knew about the documents. I'd like now to focus on when you yourself contacted persons initially. Was the information you provided about the documents being made public news to them in general, or had they heard about this before from other means?
We provided that exercise started only with the people, and we called the people which name was in the document.
And did those persons whose name was in the document, when you called them, did you understand that they already knew their name was in the document or that these documents existed? Or were you the person informing them of that event?
Some of them, they knew about document. Some of them, they knew their name was there. But most of them, they didn't know that their name was there. Majority of them, they heard about the leaking of or publishing of those documents.
And in general terms, the majority that had heard, did you get any sense of how they had heard, from other persons or from other means?
I learned during the phone calls that they find out from the media. It was all over the media in Kosovo and the region. Some of them who find out about their names, they heard from the family members or from the friends that their name is published and public in the media.
Your Honor, I'd like to seek admission of this note.
In relation to that, Your Honour, obviously the document is put forward not as truth of the statement made by the third party whose name is redacted, as I understand it. And if that is right, my understanding is correct, then I don't raise an objection.
Thank you, Your Honor. The SPO is, of course, aware of Your Honor's ruling in the bar table motion decision. However, the situation has changed now. These notes that we're addressing thus far were authored by the witness. You have the witness who's here to explain the content thereof, what happened, the process, both generally and more specifically. You also have received information about who was contacted and how. And for those reasons, we do seek admission for the truth of its contents, both in relation to the already admitted item and this one.
There's no question that they are offering it for the truth of the matter, and that makes it hearsay, and I understand that. And we will give it the weight we deem to be appropriate under the circumstances. But this man is here to be cross-examined by you, and we will admit it. There's no prohibition against hearsay. We were talking in our bar table. We were talking about the cases where they were completely unable. When the witness that had signed it, the man who had signed it was not the witness who was going to appear in court.
No,
So we will admit the item. We will admit the exhibit. I understand your objection. We will give this information the weight it should have during our deliberations. So it is being offered for the truth of the matter. And you've stated your objection.
I've stated my objection.
Yes.
Your Honor, that will be exhibit P131.
P131 is admitted. Mr. Potts, you were supposed to give us the classification recommendation on each of these items as well. So the last one and this one.
Yes, my apologies, Your Honor. The classification should remain confidential. While I am eliciting some information from these documents in open session, I have tailored the examination with a view to keeping things in open session. However, the rest of the contents, for example, dates and other specificities therein, would mean that publishing these documents and making them publicly available on the website might lead to, for example, the contacted witnesses themselves being able to see that the information they provided to us is now publicly available. And these and similar reasons were advanced when we made our submissions, when we sought admission to the bar table of these items. So we are, at the moment in court, eliciting the kind of information we believe can be made public. In terms of the remainder of the information, we believe that that should not be made publicly available.
I'll take the classification under advisement for now. Thank you. Go on.
I'd like to show the document 084008 to 084010. And Mr. Witness, that is tab 180 of your binder. Mr. Witness, do you recognize this document?
Yes, I do.
Could you tell us what it is?
Can you? Okay. I'm sorry. Can you repeat the number?
The tab number is 180.
Okay. Yeah. This is my declaration. I wrote. That's my first declaration.
And on the last page of this document, 084010, is that your signature that we see?
This is my signature.
I'd like the court officer and also the witness to turn to the first page, 084008, and I'm going to be referring to paragraph 6, which starts on this page and then continues on the next. Paragraph 6 reads as follows. Tens of the witnesses with whom the SPO was in contact after confidential documents were made public by the KLA WVA noted that they felt worried, stressed, unsafe, threatened, and/or intimidated in the wake of the publications. Mr. Witness, is that accurate according to your recollections based on the contacts that you had and the other contacts you were aware of at the time?
This is accurate to my contacts, and this is written by me.
The paragraph goes on to state, the following are some non-exhaustive examples of information provided by such witnesses during their contact with the SPO. Before turning to one of these examples that you provide in the declaration, could you tell us the basis for the examples in the declaration? What you base those examples on?
I based those examples on my contacts with the witnesses.
Do you recall whether it was just contacts which you carried out yourself, or was it also contacts that you had knowledge of conducted by other persons?
Mostly they are about my contacts carried by people, but some of them, because I reviewed some notes, are also from the other colleagues.
And in the circumstances, shouldn't the witness concentrate on those persons that he spoke to himself?
Yes, Your Honor, if I'm allowed to continue my examination, I will certainly do that. And if there's an objection later on that's not preemptive, it will be received. I'm going to turn to paragraph 7 of this declaration, which is on page 084009. And here we see one of the witnesses...
Your Honour, is the witness going to be examined by Mr. Prosecutor? Or, because just reading out the declaration doesn't, in my submission, amount to a proper approach to questioning in direct examination.
Your Honor, if I may, if perhaps I'm allowed to get to the question I'm trying to put, then the scope of my examination would be clear for everyone. And after I put such a question, if there is an objection to it, it can certainly be made at that stage.
Allow him to finish the question before you object.
Paragraph 7 of this declaration reads as follows. One of the witnesses stated that after learning of the publication of confidential information, he felt panicked and worried about his safety, so he first moved out of his house and then left Kosovo. Now, before I put my question, I'd like to show another document side by side with this declaration, and that is the document we saw moments ago, which is 093386 to 093387 RED, tab 354 of the binder.
That has an exhibit number.
Yes, Your Honor, for the record, that is P131.
So please refer to them by exhibit number.
Yes, Your Honor, I will endeavor to do so. So we are now looking at the declaration and exhibit P131. Mr. Witness, if you recall the contents of the official note we saw earlier, and you bear in mind the paragraph that I just read from the declaration, do you recall or remember whether the information in paragraph 7 of the declaration is based on the note that we addressed earlier today, P131?
Information in paragraph 7 are based on this official note.
I'd like to show another document to the witness, and that is 089886 to 089886 RED, and that is tab 228. Do you recognize this document, Mr. Witness?
I recognize this document.
Is that your signature at the bottom of this document?
This is my signature on the bottom of this document.
And in general terms, do you remember the conversation described in this note that you have before you?
I remember conversation in this note.
At paragraph 1 of this note, there is a reference to a person telling you, inter alia, that he felt stressed because of the documents leaked to the media. Do you recall being provided with this information during this or other calls?
Yes, I recall.
I'd like to seek admission of this document, Your Honor.
Please assign a number.
Your Honor, that would be exhibit P132.
The next document I'd like to show is Apologies, Your Honor. The next document I'd like to show is 089908 until 089908 RED, and that is a tab 229. Do you recognize this document, Mr. Witness?
I recognize this document.
Is that your signature at the bottom of the document?
This is my signature on the bottom of the document.
And do you happen to recall the conversation recorded in this document?
I recall. Yes, I do.
At paragraphs 2 and 3 of this note, we see reference to a person who told you and a colleague that he is not worried about the leaks and that he does not have any security concerns. Do you recall being provided with the information in this note?
Yes, I do.
And I think you told us earlier today that there were some persons who expressed similar sentiments. Is that correct?
It is correct.
Your Honor, I'd like to seek admission of this note.
That exhibit will be admitted. Please assign a number.
Your Honor, that will be Exhibit P 133.
I'm sorry, couldn't hear you.
Exhibit P 133, Your Honor.
P-133 is admitted.
The next document I'd like to show is 091902 to 091902 RED, and that is at tab 320. Do you recognize this document, Mr. Witness?
I recognize this document.
This note refers to a meeting with someone whose name is redacted, and you can see in the first paragraph the date of this meeting. I won't specify, since we're in open session, out of abundance of caution. At paragraphs 2 and 3, the note refers to this person telling you he's a little worried because of the general security situation, and particularly because of a certain announcement from the KLA veterans. Do you remember the meeting described in this note?
Yes, I remember the meeting.
And given the particular date of this note, do you recall whether this meeting was planned in relation to the events, or was this meeting already planned and this information just came up?
This meeting wasn't planned.
So did you plan this meeting because of the events which took place in September 2020, or were you going to meet this person regardless, if you remember?
This person contacted me and asked for the meeting.
When did that person contact you, if you remember?
The same day, which is in the official note.
I'd like to seek admission of this note, Your Honor.
There is an objection in relation to this note. It's not made on the face of it until some 5 months after the event.
Yes, Your Honor, I'm happy to clarify that with the witness, but regardless, that may go to weight, not admissibility, but I'm guided by Your Honor if you want me to clarify now or that can be clarified later.
I'm sorry, go ahead with your clarification. Thank you, Mr. Reese.
Mr. Witness, as counsel for the defense noted, here we see two different dates. The date in the table is a few months later after the date of the encounter as recorded in this note. Could you provide any information, if you remember, as to why that may be, why there is this gap in time?
The gap in time is because of the lockdown, and we didn't have opportunity, and we haven't been allowed to go in the office that we can submit all our documents in the Xylab.
Do you by any chance remember whether the information you recorded in this note, did you record it on the same day or soon thereafter, or did you only record it several months later?
I record all my official notes immediately after the meeting or after the phone calls.
So to be clear, you would have recorded the information we see here near to the date of the events, but only later sent this document to be registered in the office. Is that correct?
It is correct.
Your Honor, I hope that clarifies, and I again seek admission of
Anything
this
further,
item.
Mr. Reese?
Nothing further, but I maintain the objection.
Okay, thank you. This document will be admitted if the court officer will assign a number.
Your Honor, that will be Exhibit P 134.
P-134 is admitted.
The next document I'd like to show is 091907 to 091908 RED2, which is at tab 324. Do you recognize this document, Mr. Witness?
I recognize this document.
This note refers to calls on different dates within the same month, during which you and a colleague contacted multiple persons whose names are redacted. At paragraphs 2 and 3, the note refers to contacted persons expressing anger and concern when they were informed that the KLA War Veterans Association had made their names public. Do you remember the calls described in this note or similar calls thereto?
I remember these calls.
And just one detail, Mr. Witness, if we look at the table where we have other attendees, we see LA11. In general terms, could you tell us who that would refer to? And I mean a position rather than a name here.
It referred to the language assistance in Specialist Prosecutor Office.
Your Honor, I'd like to seek admission of this note.
Perhaps the prosecutor could deal with clarification of the dates, the discrepancy there, please.
Yes, please do. I noticed the same problem. Thank you, Mr. Rees.
Certainly, Your Honor. Mr. Witness, in this case, we also have a date in the table which is a few months after the dates referred to relating to the incidents. Could you explain why that may be?
These notes are prepared after the phone conversations and submitted in ZAI few months after because we haven't been allowed to go to the office.
And just for clarity, when you say submitted in ZAI, could you briefly explain what that means?
In our system in ZAILab.
That's within the SPO?
This is in SPO system.
Your Honor, I hope that clarifies, and I seek admission.
I do object, but have nothing further to add, as it were.
Thank you. Please assign a number.
Your Honor, that will be P135.
P135 is admitted.
The next document I'd like to show is 093379 to 093379 RED, and that is at tab 352 of the binder. Do you recognize this note, Mr. Witness?
I recognize this note.
At paragraph 2 of this note, there is reference to you receiving a message in September 2020 in which a relative of a person whose information is redacted states that his family informed him and others that the name of a person whose information is redacted became public in the leaked documentation, and he decided to bring his relative and the rest of his family somewhere which is also redacted in this note. Do you happen to recall this message described in this note?
Yes, I do.
And do you happen to remember what kind of a place this person said he was taking his family member to? Was it another town, another country, in general terms?
It was another country.
Paragraph 4 of the same note refers to you and to a colleague contacting the relative of a person whose name is redacted once again in the same month on a separate date. And we have reference to your colleague informing the person that the name of the person which is redacted here was published in the leaked documents. Earlier you described this process. Is this part of the regular information provided during such calls?
Yes, it is. As I explained earlier, after the leak document on 22nd of December, we decided to have that exercise, and this phone call was part of that exercise.
Your Honor, I seek admission of this note.
Any objection?
Perhaps again the prosecutor could assist with clarification on the dates that appear at the top alongside the date row and indeed in the document itself.
It's a 7-day difference.
I note counsel might be referring to the topmost date on the left, and I'm happy to clarify, Your Honor, it is a longer difference.
Go ahead.
Thank you.
Excuse me, Mr. Rees, I didn't notice the other date.
Thank you, counsel, and thank you, Your Honor. Mr. Witness, in this case, we see 3 different dates on this note. There is one date on the top left, which is dated in a month this year. We have a date in the table from September last year, and in the text also from September last year. If you're able to, could you explain why this may be that we have 3 separate dates in this instance?
I can explain that this second date is a typo.
To be clear, which second date are you referring to? The one in the table, the one in the text?
In the table.
So to be clear, the one in the table should contain the date we see on the top left. Am I understanding correctly?
No, it's date from bottom, from the text. It should be from the text.
So then, and I'm sorry to continue on this line of questioning, but the date that we see in paragraph 1 is the date of the event recorded, is that right? The event recorded occurred on the date in paragraph 1?
No, it's in paragraph 4.
Yes, in paragraph 1 we have reference to a message, my apologies. In paragraph 1 we have reference to a message being received on a certain date, and then in paragraph 4 to a call. And that's correct that those occurred on separate dates, right?
That happened on the separate dates, and there was also one more call in between.
And then when did you submit this document into evidence in Xylab as you referred to earlier? Would that be the date on the top left of the document?
That is the date on the top left on the document.
So which date would you replace the date in the table with? The one in paragraph 1 or paragraph 4?
With the date in paragraph 4.
Thank you, Mr. Witness. In your honor, we seek admission.
Any objection?
Same position as before.
You can just call it an ongoing objection if you wish.
Objection.
Okay. Please assign a number.
Your Honor, that will be P136.
Go ahead, Mr. Pouch.
I'd like to show 093388 to 093388 RED, and that's at tab 355. Do you recognize this document, Mr. Witness?
Yes, I recognize this document.
This note refers to a call you made to someone whose name is redacted, and to this person telling you that although he did not feel threatened, he felt concerned because of the leaking of files from the SPO. Do you remember the calls described in this note?
Yes, I remember the call.
And in this note, we see 2 different dates. We have a date from this year on the top left, and then the same date from last year in the table and the text. Could you explain why that may be?
Different dates. Dates in the text is date when I called the witness, and date on the top of the document left is date when I submit this document in Xylab in our evidence.
Your Honor, I seek admission of this note.
Objection.
Objection is overruled. Please assign a note, or a number, I mean.
Your Honor, that will be P137.
P137 is admitted.
I'd like to show the document 084232 to 084233 RED, and that is at tab 184. Do you recognize this document, Mr. Witness?
Yes, I recognize the document.
Do you remember the conversation described in this document?
Yes, I remember conversation.
At paragraph 4, this document refers to a person who told you and a colleague that he supports the work of the court, but that it is very concerning that these documents were leaked. Do you recall being provided with information of this nature in this or other contacts?
Yes, I do.
In relation to this note, we see there is a name in the table of an associate prosecutor, and that is the same name of the person who signed this note. We also see your name under the title Other Attendees, and then we have a reference to an interpreter. Sorry, I was just going to ask a question. Does this mean, Mr. Witness, that while you did not author this note, since it's not your signature, you were present during this interaction that's documented in the note?
I was present during the interaction.
Your Honor, we seek admission of this note.
We do object, and I would like to address this and the further notes which I anticipate Mr. Pache to be moving on to additionally. The trial panel gave the decision on the prosecution request for omission of items through the bar table on the 29th of September 2021. It's filing F00334, and it would assist if the trial panel had the decision in front of it, because I wish to refer to parts of it. In that application, part of it, of course, related to these very notes. And in paragraph 90.
Just a second. Mr. Rees, before going into what we said, what is your objection? Just state your objection. Is it hearsay? Is it lack of confrontation?
Well, and it's inconsistent and contrary to the ruling that the trial panel has already given.
Okay, but we don't need to have the rule read back to us. We wrote the rule. We wrote the order.
Well, I certainly follow that, but
I understand
with
your...
the greatest respect, it's difficult to recall every utterance.
Let me put it this way. I'm going to sustain your objection.
I'm grateful. But, well...
The fact of the matter is that this was not authored by this person.
Yeah.
No one's here to be cross-examined. You can't confront the witness, and I'm going to sustain your objection.
Thank you.
Your Honor, so I take it that the item is not admitted into evidence?
Not admitted.
Your Honor, I think this would be a convenient time for a break. I can already inform you that I would not require too much time after the break. It won't take me the entirety of the next session.
Can I ask you a question?
Certainly.
Is it your intention to submit more notes by people who were not the author of the note?
Yes, Your Honor. So I'm very mindful of the guidance you provided this morning, and as is evident to everyone, it seems, the next set of questions will indeed be about notes that, sorry, Your Honor, I'm not sure if you want me to make these submissions in the presence of the witness or not. I don't think it's controversial, but perhaps you deem it best.
It's very difficult to cross-examine somebody who is not here, and so you be guided by what we just said, and
yes, Your Honor.
Take a look at your potential questions
Certainly.
during the break, and we'll talk about it later.
Certainly. Thank you, Your Honor.
We are adjourned until 2:30. Oh, I'm sorry, Mr. Reese. Everybody back down. Mr. Reese was standing up. Yeah, the witness can be excused.
Yes.
Thank you, Mr. Jukic. Jukic, be back at 2:30. Can I, while we're at it, I want to, before you speak, I want to clarify a little bit that just the fact that the evidence is being heard, these notes that we have admitted are being heard and being admitted, and his testimony about those notes, I recognize the fact that the person being questioned is not here for you to cross-examine. The fact that we hear that testimony or admit that note is no indication of the weight we are going to give that testimony. The panel is aware of the inability of the defense to be able to effectively cross-examine the person who was questioned because those witnesses are not called. And I just wanted to make it clear on the record that we understand that situation. We understand your objection, but we are admitting them as hearsay for the purpose of, because they are relevant, they are probative, and we believe they're authentic in this case because the witness was here who actually examined those or talked to those witnesses. So anyway, go ahead with your statement then.
On that point, if I may, Your Honour, clearly I understand that the witness can give evidence that the note is an accurate account of what was said to the witness. I follow that. But in the decision on the bar table motion, Your Honours did deny admission to establish the truth of the matters asserted in the notes by the witnesses with whom the SPO spoke. Now, I follow that the trial panel has heard evidence from this witness as to what was said to him, and indeed he has said to other SPO officers, which perhaps goes beyond the scope of the previous ruling, but there we are. We will submit that in accordance with the trial panel's ruling, whereas what has been said by others has been admitted, it's not been admitted and cannot be admitted for the purpose of establishing the truth of the matters said by the third party to this officer, or indeed other SPO officers, because that would be inconsistent with the trial panel's ruling on the bar table motion.
Well, the bar table motion was some items were denied admission, but not because they were inadmissible, but because we needed more information before we could admit them. They were not admitted under the bar table motion. I don't think they were, I believe I'm correct about that.
Well,
in other words, they now have provided more information, and we are allowing those documents to come in.
No, and I follow that, but of course, a document could be admitted for one purpose or more than one purpose. And it's certainly in paragraph 93 of the ruling, that Your Honour said, the panel finds the probative value of the content of the contact notes, if any is outweighed by their prejudicial effect, and that consequently their admission and evidence for their content would severely erode the rights of the accused to confront in an effective fashion the case presented against them. For the reasons and considering its obligation to guarantee the fairness of proceedings, the panel denies admission of the proposed contact notes to establish the truth of the matters asserted in those notes by the witnesses with whom the SPO spoke. The present ruling is without prejudice to the possibility for the SPO to use and request admission of certain contact notes, one, through the testimony of a witness who authored the notes, two, for the limited purpose of describing the procedures followed by the SPO in interviewing these witnesses, as well as the resources used and time spent on such interviews, to the extent that such witnesses have knowledge of such matters. So for that limited purpose, not for the purpose of establishing the truth of the matters asserted in those notes by the witnesses with whom the SPO spoke.
Well, among other things, it's also corroborating the testimony that this witness has already given about what he found out during his conversations.
And I follow that, and that is a limited purpose. So I understand that the note has been admitted because it demonstrates what he was told. The only point I wish to clarify was that in accordance with Your Honour's ruling on the bar table motion, it doesn't go further than that and be used as evidence of the truth of what the third person said to Mr. Jukic. That's a different matter, and one of which he can't comment on the truth or reliability of that information.
And he isn't commenting on it.
No, he's not.
He's asking that the document be admitted for what it says. This is still going to the weight of the testimony. That's what we have to decide on it. And we've heard the testimony. We've admitted the exhibits. We will decide the weight to be given this. I've told you that we have some limits to what we can accept out of this witness's testimony and out of these documents, and we intended to carry that through, but that's going to be our ruling. So I appreciate your candor and the argument, but what are you asking us to do?
I'm not asking, at the moment, I'm not asking the trial panel to do anything other than the next request, which I will again be candid.
No, okay.
And this is what I'd actually risen to my feet about, Your Honour.
Well, bear in mind, you're going to have an opportunity to cross-examine this witness too, and to talk to him about some of these issues.
Well, indeed. And it's on that point. It's on that point that I.
That's why we didn't admit them from the bar table, and we asked him to be here so that we could actually hear his testimony, and you could cross-examine him.
Well, I can't cross-examine him on whether what he was told was true or not, can I? Because the person who told him that is not there. But leaving that aside, Your Honour, the reason why I rose to my feet, in fact, is because I wish to press the request that I made earlier in the week in relation to cross-examination. And I would wish to conduct my cross-examination to begin it next week, next Thursday morning. That's the request that I wish to make. We have heard significant testimony which doesn't feature in the declarations, and I'm not revisiting that issue, Your Honour. I'm simply referring to the request I made earlier in the week.
We'll take
Your
that
Honour,
into
if I may be
consideration
heard.
and rule on it. I'm sorry, Mr. Potch. I didn't mean to ignore you. You want to speak? Go ahead.
Thank you, Your Honour. Just very briefly, the prosecution does object to any delay in cross-examination.
The speakers are kindly noted to slow down for the purposes of interpretation. Thank you.
Take me a maximum of 15 or 30 minutes following the break to complete my examination. It's in the interest of the efficiency of proceedings to start with the cross-examination at this point. There have been no valid reasons presented as to why there should be a delay in cross-examination. The reasons put forward to Your Honours earlier this week have been rejected because there is to be no further 1023 disclosure. There was no weight given to the argument that there is anything beyond the scope, or it's impermissible to go beyond the scope of the declaration. So there is truly no reason not to start cross-examination today.
Thank you. You might tell us your reason, again, why this gentleman's testimony, if there's only 20 minutes more, is so difficult that you can't cross-examine him today.
Well, our submission remains that there are significant parts of that testimony that we will not find in any of the declarations, so we did not have notes of it. I understand the ruling of the topics involved, but the detail was not in any of the declarations. We do wish to consider, again, Your Honour's remarks this morning about disclosure. It is, of course, an ongoing obligation that the prosecution has. And frankly, I am aware of the time estimates we gave previously. I hope that the trial panel will have recognised that we tend to err on a pessimistic side and then aim to better the worst case scenario. And I am of the view, and I'm confident of this, that we will not lose time if we are allowed to reflect on what has been said today in the transcript and carry out our cross-examination in one session on Thursday.
Your Honour. Thank you, Your Honor. Just simply to say that there has been nothing surprising from what we heard today. Much of this is covered in the declaration. All of it is covered in the declaration when you combine it with the summaries of anticipated testimony, in addition to the 3 points, perhaps, that were provided 2 weeks ago pursuant to the conduct of proceedings. And the last thing I'll mention is it's also that the notes that we are addressing, which has taken up the majority of my examination, have been disclosed to the defense a while ago. The defense have been on notice of the items I may use with this witness several weeks ago. So there truly is no reason. If there is anything the defense itself considers surprising, they are within their rights to address that later on.
We'll take it under consideration, Mr. Reese, during the noon hour, during the lunch hour, and we'll come back and let you know. You may have to do a cross-examination, you may not today. I will tell you, I went back and reread all of this material, and I haven't heard anything from the witness today that is out of, that couldn't have been anticipated by reading the disclosure and the following matters.
Well, I understand that Your Honour's insight is greater than mine. Certainly, as I listened to the evidence, there are many aspects that I did not perceive, did not appreciate, and are entirely new to me, and I wish to explore in some detail. And I will do that more concisely and more effectively and more efficiently for the trial panel to know if I am given time to reflect upon that.
What about you, Mr. Cadman? Would you want to proceed with cross-examination today?
No. Put very simply, we have planned, based on discussions that took place earlier in the week, when Your Honours has said that we would be given time until Thursday.
Okay.
And
well,
as Mr. Rees has set out, there are matters that have been put in evidence today that we were not previously aware of.
We will take it under advisement. We'll give you an answer when we come back after lunch. Thank you very much. We are adjourned.
All rise. All rise.
Be seated. Before we bring back the witness, we will address the points raised by Mr. Rees. Mr. Rees, I don't want you to make a habit of this, but you may be right about something. In our bar table decision, that is F334, paragraphs 93 to 94, we made it very clear that contact notes would not be admitted to establish the truth of the matters asserted in these notes by the witnesses with whom the SBO spoke. So in other words, the panel reiterates that the notes contain hearsay evidence which could affect the weight to be given to them. The panel also notes that the notes suggest that Mr. Jukic was told of fears and concerns expressed by a number of witnesses, and that evidence is now corroborated by his account in court. If the defense disputes that this was said, the defense can challenge that assertion in cross-examination. In contrast, what was made clear in our bar table decision, the panel will not rely on any admitted contact notes to establish the truth of the expression of fear and concern recorded in those notes. This does not mean that the panel cannot rely on any admitted contact notes to ascertain that Mr. Jukic spoke with those witnesses or what they told him. This goes to the exception the panel carved out in paragraph 94 of its bar table decision, where it said that the SPO could use and request admission of certain contact notes through their authors for the limited purpose of describing procedures followed and resources on such interviews. Also, nothing stops the SPO from eliciting Mr. Jukic's knowledge during direct examination about whether, in his professional assessment, witnesses he dealt with were threatened in the wake of the publications and what measures the SPO had to subsequently undertake to ensure the safety or well-being of those people. This is also clearly stated in the SPO summary provided for this witness as filed on 1 October. That is F347. I hope this clarifies. Now, in relation to your request to start cross-examination of Mr. Jukic next week, the panel is aware that you raised this matter on Tuesday morning. While the panel stands by its observations that so far nothing was heard from the witness that couldn't have been anticipated by reading the disclosure in the notice given, we will grant your request, and you can start cross-examination of Mr. Jukic next week. But then we expect your examination will be done more concisely and more effectively and more efficiently as you promised, knowing now how we rule. Before we go any further, before we adjourn for the day, we will proceed with the balance of the direct testimony, and then, even though it's out of order, the panel may have some questions prior to your cross-examination. So you can bring the witness back in, madam.
Your Honor, maybe while we wait, just a clarification on classification of exhibits. I stated earlier in relation to the first two exhibits that were admitted that we maintain they should be confidential. The submissions I made about those items refer to all items today, which are P130 to P137. Should the panel be inclined to make those documents available on the website, the SPO would request some time just to apply redactions to names of staff members and to the dates of the events recorded in those notes.
All right, thank you. Thank you, Mr. Potch. We will consider those items. Mr. Jukic, you may take a seat. We will proceed with your direct examination at this time. Mr. Potts, you have the floor.
Thank you, Your Honor. Good afternoon, Mr. Witness.
Good afternoon.
Earlier today, we discussed your declaration, and you stated that you based the examples contained in the declaration on your own contact with witnesses and on contact by other colleagues, which you had reviewed. And I'm here referring to page 72, lines 1 to 10 of today's transcript. I'd like to show you the declaration again, and that is 084008 to 084010, and that's at tab 180. And if we could turn to page 084009, please. I'm going to read from paragraph 11, which contains the following.
Your Honour, before Mr. Pache does that, if the purpose of the questions here is to adduce that these examples in the declarations are based on the content of witness contact notes that this witness did not author, we would submit that that is objectionable and falls foul of the trial panel's ruling.
Mr. Patch.
Yes, Your Honour. I do intend to ask certain questions. Once again, I've not been allowed to go there yet. What I intend to do is based on my understanding of Your Honour's guidance this morning, which is establishing a foundation in relation to notes I'm going to show the witness, and then proceed if that foundation is laid.
Go ahead.
Paragraph 11 of the declaration reads as follows. A witness stated that he was informed by friends that his name was in the confidential documents, and that he immediately took measures to enhance his children's safety. He noted that he had started to feel like people were isolating him and his family, and that people did not seem to differentiate between witnesses and spies, adding that he felt that his family was endangered. Before I ask my question, I'd like the court officer to pull up side by side with the English version of the declaration, item 084247 to 084248 RED, and that is at tab 188.
It looks like I anticipated correctly. And what Mr. Pache is trying to do is elicit the content of witness contact notes that this witness did not author, and that is in breach of the trial panel's ruling.
Your Honour, this is exactly the same objection that was made before, and you allowed me to continue my examination. As I said, I can repeat it.
Well, let's start out with a preliminary. Does this witness have anything to do with creating this?
Yes, Your Honour. In my submission, as I read out, I paraphrase from what the witness said earlier today at page 72, lines 1 to 10, where he stated that for the purpose of creating the declaration, he also reviewed notes by other persons. And the content of those notes is reflected in his declaration. So I am now seeking to elaborate on that information by pointing to a paragraph that I just read, and I'm now going to ask if the basis for the paragraph is that in the official notes. In our submission, Your Honour, this falls squarely within your guidance this morning. We will not seek admission if that is the concern, also based on your guidance this morning.
Overrule your objection. Go ahead.
Mr. Witness, if you could direct your attention.
I did rise whilst
I'm sorry.
Whilst you were conferring.
I'm sorry, I didn't see it.
The concern is you asked Mr. Prosecutor whether this witness was involved in authoring that report. There's no mention. We only have to look at the official note. There's no mention of this witness.
Thank you. Go ahead, Mr. Pache.
Mr. Witness, I'd like you to focus on the official note, which is on the left of your screen and also at tab 188. and I note that in paragraphs 1 to 3 of this official note, we have reference to someone stating that some friends had told him about his name being included in documents recently released by the KLA War Veterans Association, and that this person took his children out of school as soon as he found out about this. We also see at paragraph 6, which is on the next page of the official note of the court officer, could go to 084248. Thank you. Paragraph 6, the note states the person said he started feeling that people were isolating him and his family, that people did not differentiate between witnesses and spies, and that the leak endangered his family. Mr. Witness, having read, or rather having listened to me read, paragraph 11 of your declaration, as well as a summary of the contents of this official note, could you confirm, if you remember, whether that paragraph in your declaration was based on this note?
The paragraph 11 was based on that note.
And this note does not mention your participation in the contact. Do I take that to understand that your only knowledge of this information in the note was pursuant to your review of the note produced by your colleagues?
Not only. I was in the meeting as well.
And what meeting are you referring to in this instance?
In this meeting, I was an observer of the meeting. Not participate in the meeting, but I was there.
And are you referring to being an observer in this meeting on the document on the left? Is that correct?
Yes.
And is that, why then is there no mention of you having attended in this note?
I don't know.
I'd like to turn to another paragraph of the declaration, and that is paragraph 12. And again, the declaration is the document on the right, which for clarity is 084008 to 084010. And paragraph 12 reads as follows. Another witness stated that since his name featured in the confidential documents, people were looking at him and his family differently, and his business had lost customers. I'd like the court officer to replace the document on the left of the screen with 085880 to 085883, tab 191.
Your Honour, can I ask, rather than be put in a position where the prosecution adduces the content of the declaration and the note, and then subsequently goes on to deal with what involvement this witness had with the meeting or contact that's reported in the note, perhaps if we could start with what involvement this witness had, and then work from there, that would save us some time in dealing with objections, I would have thought.
Your Honour, I believe I'm leading the direct examination. I've been allowed to proceed in this manner, and I see no reason to change that.
You may continue.
Thank you, Your Honour. Mr. Witness, I direct your attention to the note on the left of your screen, which is that at tab 191. And it refers to a call by a colleague of yours in September of 2020, and that paragraph 7 and 8, which are on the first page, it refers to a person telling your colleague that the leak of SPO documents in the media raised very serious security concerns for him and his family, that people looked at him and his family differently, that he lost customers, and that the publication of the document is bringing the family into a difficult financial situation. Mr. Witness, could you confirm that the paragraph I read to you earlier from the declaration, in this case paragraph 12, which appears on the right-hand side of your screen, was based on the information, the official note, on the left-hand side of your screen.
Yes, I can confirm.
And in this instance, Mr. Witness, could you clarify whether your knowledge of the information in the official note that we just read is something that you learned of through a meeting or through a review of the documents you conducted for the purposes of your declaration?
I learned during the review of the documents.
I'm now going to address paragraph 10. Madam Court Officer, the document on the left can be withdrawn. We'll keep the document on the right, please. The declaration, once again, is 084008 to 084010. And I'm now going to read from paragraph 10, which reads as follows. A witness noted that because of the confidential information being made public, the pool of people who could potentially harm his family has been broadened. The document I'd like displayed on the left side of the screen is 089938 to 089939 at tab 234. In the note appearing on the left side of the screen, we see reference to a call by a colleague of yours, Mr. Witness, to a person in September 2020. And paragraph 3 on this first page refers to the person telling your colleague he was aware of the leak, that he was angry because of the leak, and that his family members in Kosovo are not safe because the KLA WVA has thousands of members. In paragraph 5 of this same note on this same page, we see reference to the person stating that he thinks the leaks broaden the pool of people who could potentially harm his family, and that now the fact he collaborates with The Hague is known. Mr. Witness, once again, having reviewed paragraph 10 on the right side of your screen in the declaration, and now the official note on the left side of your screen, could you confirm that paragraph 10 of the declaration was based on the contents of this official note?
Yes, I can.
And in this case, once again, Mr. Witness, can you clarify the basis of your knowledge for this? Was it your attendance at the meeting, although it's not reported here, or was it that you reviewed this document as part of the review for the preparation of the declaration?
I learned about this from the reviewing of this official note.
The document on the left side could be withdrawn, and we will turn our attention to paragraph 8 of the declaration, which reads as follows.
Excuse me, Mr. Pacha. Am I correct that you're intending to rely on this information in some way? Is it going to be used for something? Are you going to offer an exhibit?
Your Honor, based on the guidance provided, I don't intend to tender the official notes.
And
for admission.
These triple hearsay statements that are being made have almost no probative value, and I'm just questioning how long we continue with something that doesn't accomplish much.
Yes, Your Honor. Of course, I'm guided by your statement just now. I was going to go to the rest of the paragraphs and conduct the same exercise. If Your Honor deems that that's not necessary.
Is it your intention to offer these paragraphs then?
So, Your Honor, I was not going to tender the official notes based on your guidance this morning. If Your Honor would allow the declaration to be tendered pursuant to Rule 154, we could go through the procedure with the witness.
But you've got the witness right here. Why do we need this?
Yes, Your Honor, but it's a matter of eliciting the information in a declaration which he produced based on information he reviewed in his capacity within the office.
And that's a good question. Did you get information from your office? And he said yes a long time ago. And I don't see the point of any of this. We've asked for a long time, are there going to be witnesses who come here and testify about this? And we've been told, no, we're going to have other testimony, and we've allowed it, but we aren't accomplishing much because there's not much probative value to this.
Certainly, Your Honour.
You go ahead and finish your direct examination. I just think you need to know.
No, Your Honour, in that case, I will not ask any more similar questions. I'm guided by Your Honour's assertions. If you just allow me 1 minute to confer with my colleagues.
Sir.
Thank you for the time to confer, Your Honour. In that case, we don't have any more questions for this witness. And that concludes my direct examination.
Thank you, Mr. Pacha. As we stated earlier, the cross-examination by defense will occur next Thursday at 9:30. Yes, Mr. Pacha.
Sorry, Your Honour, just one matter for clarification. Despite the postponement of the cross-examination to next week, based on our understanding of the order on the conduct of proceedings, the list of items to view should be disclosed now, essentially, because I concluded my... Yes, right. Thank you very
How
much.
quickly can you list your items for cross-examination?
We'll do it today.
Okay. That's fine. Later today was the answer. There will be some questions of the witness by the panel members, beginning with Judge Gaynor.
Thank you, Mr. President. Good afternoon, Mr. Jukic. In your evidence earlier, you told us that you've been employed by the SPO since September 2019. Now, I accept that there's been, of course, a great deal of disruption as a result of COVID-19. But could you give us an idea of how many and what kinds of staff within the SPO you've dealt with as part of your professional duties since you began in September 2019?
So when I start work with the SPO, we've been 2 witness security officers and witness security and handling team leader. And then in the spring 2020, that group grew up. We have 5 witness security officers and 1 witness security and handling team leader.
Okay, and from your evidence, I understand that you deal with investigators and prosecutors. Is that right?
Yes, that's right.
And you deal with them on a weekly basis or a daily basis?
I deal with them on the daily basis.
Okay. Now, as a result of your professional experience since September 2019, do you have any reason to believe that any current or former member of the SPO was involved in any way in delivering unauthorized information to the KLA War Veterans Association?
No, I don't have.
Do you have any reason to believe that any person acting or under the instructions or control of the SPO was involved in any way in delivering information, unauthorized information, to the KLA War Veterans Association?
No, I don't have.
Thank you, Mr. Jukic. Thank you, Mr. President.
Thank you, Judge Smith, and good afternoon, Mr. Jukic.
Good afternoon.
Understand from your account of this morning that it is part of your responsibilities and your team's responsibilities to make security assessments of witnesses. Is that correct?
Yes, it is correct.
And can you tell us in general terms what are the factors or considerations that you take into account to make that determination, that assessment?
After the interview given to the SPO, witness security officers doing witness security briefing or short interview with the witnesses, collecting all that data about him, his family, data about contacts, and about threat. If there was any threat before, if a witness feel unsafe or threatened by anyone, or if he expect any kind of the threat. So that we are mainly focused on the threat assessment after the interview.
And would the context in which the witness in question find him or herself be relevant? In particular, I mean, the location at which the person is, whether it's in Kosovo or outside Kosovo, would that be a relevant consideration for your purposes?
Yes, of course, we take all the facts into account. So it's different if person is living out of the Kosovo or in Kosovo. And what kind of the witness is, if that witness is a victim or just witness or witness insider. So we are taking all that facts into consideration during our assessment.
I'll come to your point about victims in a second, but can you tell me first one thing you just said, that you take into consideration whether the person in question is located in Kosovo or outside of Kosovo. Why is it relevant to you, to your security assessment or threat assessment, that someone might be located in Kosovo at the time?
Because in Kosovo we have a kind of the power. As a SPO, we have people present in Kosovo who can react and help to the person, to the witness. But in other countries, we need to request for the help from the other authorities, send a request to protect that person.
Thank you. At page 57, 58 of the live transcript of today, you explained, you gave evidence about the phone call that you received from a witness who expressed his concern to you, and you said that he told you, and I quote, "I know very well what happened to the witnesses in Kosovo." What did you understand the witness to be telling you there?
Because I have some knowledge and experience in the Balkan region and in Kosovo during my work for International Criminal Tribunal for former Yugoslavia. There was a lot of incidents happened to the witnesses. And also I know from my experience that there was some incidents during the UNMIC and ULEX time when some witnesses were threatened. I think that was what that person was thinking during the phone call.
And at page 47, 48 of the transcript of today, and you've just repeated it a moment ago, you explained that there were different categories of witnesses for the purpose of your professional responsibilities, and that one of these categories were victims, and you gave us a definition of what a victim was for your purposes, that is. Now, can you explain to us why you treat the category of victims as you define them as a specific subcategory of witnesses? Are there particular needs, particular consideration that go into treating these individuals?
So for the victims, we think that they are a more vulnerable person, that the victims, they were suffer some threat or harm before, so we think they are more vulnerable in the psychological way. And does that imply different measures or steps, as you described them this morning, in relation to these sorts of persons? Different steps in a way that we sometimes advise them to take psychological support or some kind of professional help to improve their health situation. Now, just assume a scenario here, and I want your opinion from the professional point of view, from your point of view, not from a legal point of view, of course, but assume that a witness discloses to the public the fact that he or she is a witness in relation to this jurisdiction. If this were to occur, does such a person lose
protection to which he would otherwise be entitled to receive from yourself and from your office?
No, it's not a reason to lose protection from our side. We discuss this with the witness. We tell them about what happened, and we ask the reason why he made public that facts.
Now, you also gave evidence earlier today that a number of individuals with whom you called, whether you called them or they called you, expressed fears and concern, and that you took some steps and measures. And in particular, that's page 60 and 61 of the live transcript, you indicated, and I believe it was in relation to one individual that he or she was relocated, and in relation to others that you took what you called emergency risk assessment. And what I want to ask you is whether such measures are regular, usual measures, or whether they are exceptional in the sense of being rare and relatively infrequent.
So when we are talking about relocation, it's really exceptional. We call it in our profession last resort. So when we don't have any other option to protect somebody in his place in the territory of Kosovo, we propose relocation for that person. For the emergency risk management plan, it's also exceptional, but it's for the limited number of the witnesses who are most vulnerable, and who are also, from our perspective, important for the prosecutor office.
So asking you in general term, and no need to give any specifics, of course, but what would justify such measures in a given case? What level of threat, in your experience, would justify such, I think your expression was exceptional measures, or exceptional, you said. What level of threat would justify such measures?
High level of threat.
Thank you.
I'm sorry, Judge Barta will have a question.
Thank you, Mr. President. Good afternoon, Mr. Jukic.
Good afternoon.
I would also like to ask you a few questions, actually. My first question is, if I'm not mistaken, you told us this morning that you and your colleagues contacted around 200 witnesses after the 3 press conferences were held by the KLA-WVA in September 2020. Is that correct?
Yeah, approximately 200.
Now, how many of these individuals expressed security concerns? If you cannot say exactly, you could maybe give us a rough estimate in this regard.
It's difficult to say, but majority expressed some kind of the concerns. Big majority.
By referring to the majority, you say more than 100?
Yes, more than 100.
And how many of these persons told you that they had received threats in or after September 2020? Also,
I can't
roughly.
recall. Yeah, I don't know. Received the threats, very few.
Very few.
Received threats, not many.
So less than 100?
Yes, less than 100.
But you cannot be more precise?
Not at this moment.
How many of these individuals you or your colleagues contacted were actually relocated? If I remember correctly, you mentioned one case this morning, a person who was relocated. Is this the only person who was relocated, or
No, it was more
are there
than
others?
one. It was more than one.
More than one?
More than one.
More than one. Can you say how many?
2.
Roughly 2. Exactly 2?
Yes.
And my last question, for how many witnesses were other security or protective measures taken other than relocation?
I can say between 20 and 30.
Thank you very much, Mr. Jukic. I have no further questions.
You're welcome, Your Honor.
All right, we will, you can escort the witness out, please, Madam Usher. Thank you, Mr. Yukich. There being nothing else, we will adjourn for the day. We'll see you Thursday at 9:30 a.m. Thank you.
All rise.